filed an application for intervention
Then the substitution, my lord, for this.
because the official liquidity.
It is liquidated because after Supreme Court judgment, my lord, it's gone to liquid. That may be allowed.
Yes, please.
My lords, in item 15, my lords, the High Court reverses a trial court.
No, but tell us one thing. Was there any invoice issued by you?
My lords, annexure P1 is the invoice which was issued.
Which page is that?
Yes, my lords. Annexure P1 is at page, what just one? Is at page 20. That's the invoice which we had issued.
And is there any signature of the person receiving the goods on the invoice?
No, my lords, there was no, there was no receiving as such, but the transporter, we had examined the transporter who deposed saying that I took the goods from my factory to his premises.
But tell us one more thing. When they reached their factory, the transporter must have taken a receipt from the person making the.
That unfortunately in his deposition, he says he
Just come, your.
Yes, my lords.
That's the trial court judgment.
Yes, my lords.
Because if there is nothing, then the judgment of the High Court is correct. We turn to the last portion of that page.
Page 93.
93. Manoj Kumar Agarwal, owner of so-and-so transport, was brought to notice of the plaintiff that he has taken so-and-so to the factory from the plaintiff, delivered it to defendant since Steel in Raipur, for which he had received 14,800 as rate.
Yes,
He has stated that the driver of the vehicle was so-and-so. He had presented the wage slip.
That we had presented, my lord.
Where is the wage slip?
My lords, I can file it. It's not.
Wage slip is by them.
Is this case the weighing slip is
No,
done at the premise?
no, it's by the.
By the transporter.
No. Wage slip is by the transporter or is issued by the defendant, because it says given by the Sin Steel. No, it's there. It's the way bridge of Sin Steel or somebody. This slip is so and so. Now turn to the name. This is the manager of the.
I'm not seeing the wage slip.
That was the main document you should have relied upon. Then otherwise you don't have a case.
No, even
pay slip the defendant saying that he has received the goods, then the situation may be different.
Purchase may have it on next Monday. I'll get that wage slip and I will file it as an additional document, my lords.
The petitioner will produce before this court the original of Exhibit P17 referred to in the trial court judgment and the High Court judgment. Relist within period of 10 days. Relist in the week commencing 17th of February 2025.
I'm obliged, my lords.
Surprise.
Before I proceed to say that tribunal's order is powers, kindly turn, we have deposited about 40 crores now. My appeal is pending before the High Court on the question whether the 2013 Act will apply or not. How does the 227 petition lights expedite the execution procedure?
Only 88 crores.
From 41 lakhs gone to 88 crores.
The similar issues pending in this court.
No.
No, my appeal is pending in the High Court.
No, but
I-
920, you have delayed it by 920.
13 Act will apply. The basic question that appeal is pending.
No, no, I understand that. But why 929 days delay?
That's the first order. Interim order. That's the first interim order.
Not with great respect.
Yes,
Not the appeal is delayed by 100,000 days.
Unless the appeal is
And
heard,
it's interlocutory order.
unless the appeal is heard,
Mr.
there are
Rothi,
227
Mr.
petitions.
Rothi, look at the amounts. I hope there is no something more
40
what
crores
cannot
have
be
been
paid.
Not with respect, if the new act applies, the amount goes
We
by
have,
time.
I have serious objections to that.
And Lord, your lordship,
Maybe
fine.
something amiss. We'll see that. Issue notice.
You know, let them deposit some money then.
40 crores is
It
the
can't be like this.
40
You know, I'm
40 crores.
just appreciate. I'm waiting for 15 years. They've taken away my land.
But you can't take away the ransom.
What ransom?
It is a ransom.
Give my land back.
It's a collusion, I would say.
Give my land back.
6,000.
I'm waiting for 15 years. They've taken away my land.
Issue notice returnable in the week commencing 24th of March 2025. Notice is served,
They will not be accepted.
accepted on behalf of
R1.
respondent number 1, representative of KU, and waive service of notice. Notice will be served on the unrepresented respondents on steps being
You don't
taken.
let them deposit some money.
7 days. It is submitted that the main appeal on the question whether compensation is to be paid in terms of 1990, the Land Acquisition Act 1898 or 1894 or the Land Acquisition Act 2013 subject matter is a subject matter which is pending consideration. Full stop. The difference between the amount payable under the first enactment and the later enactment is more than 88 crores.
Not 88 though.
88 crores.
88 plus.
Please come to page 128, your first appeal, valuation. Valuation of the appeal is 11 crores 74 lakh. 88 lakhs is what you paid as court fee. So the amount is 11 crores, not 88.
No, no. Execution court.
80%.
No, they paid.
No, they didn't pay me, Lord. With
They
respect.
paid,
With
they
respect.
paid, they paid.
41 lakhs also.
They paid,
paid.
Lord, did not pay 80%. Lord, the new act
They
has
paid,
come.
they paid. That you're wrong.
No, they paid when the new act came.
No, no, no.
No.
Earlier,
No. Lord, it's wrong. They paid 80% in
The
July
they deposited. Okay, they deposited 80.
2014, my Lord.
No, no.
2010,
Not to my knowledge.
2010.
My Lord, with respect,
Anyway, we'll see.
they have to pay me 80%.
We'll examine Mr. Rothke. We are not deciding.
I'm struggling for 20 years. I'm a
You'll get your money which is due. It's my question of money. You already 41 lakhs or no?
Not only
Some money I have been paid, but I should be paid.
He's been paid 40 crores.
deposited.
Next, sure, deposit. How much has he been paid?
45 lakhs was paid.
45 lakhs has paid.
Under the new
So
act.
so therefore, I'm saying, let them pay something.
No, we'll see. Delay,
Proceeding-
issue notice on the SLP and the application.
The execution proceeding will remain stayed.
No, let it continue. There'll be stay of operation of the impugned judgment.
Right.
Yes.
Execution. He said execution.
I'm seeking a Passover and
Again, IA is not filed. The bank had filed a
my lords, I'm requesting a Passover. Much better.
Pass.
So 19, your lordships may just orally, my lord, I'll point out what the issue is. This concerns,
No, we can't take it here. We have already rejected the petition under 32. We'll send it to one high court.
I bowed.
She appeared in that.
Please, Lordship, please.
We already dismissed that. So we'll not transfer it here. We'll transfer it
I
to
bow down.
Punjab. Punjab
There is
and Haryana.
something I want to pray. Lord, there are several petitions. Several petitions, but it's my duty to bring to your lordship's notice. The questions in each petition are sometimes different. That it doesn't match with the answer sheet, the proposed answer.
Because there are a number of questions. Somebody might have challenged particular.
What I am requesting is, Lord, if it can be.
No, we will not be. We ousted her. It will not be
No,
fair.
I'm not saying it, kindly bring it here, but I bow down. It should go to one high court. Can it be Bangalore High Court?
No, I
That
thought
there
Punjab
it's-
and Haryana High Court will be the first petition was in Punjab and
Yeah,
Haryana.
Bangalore,
Delhi-
Karnataka.
Lordship,
It was Delhi High Court was the first petition.
The division bench is hearing in
LP.
Punjab and Haryana High Court.
Punjab is first.
Delhi High Court is already hearing two LPAs because I
Not the difficulty is, my lord, others will lose one right of appeal. That's the reason.
No, that may be so, but they have the right to come here. That will not be.
Because Delhi High Court has already passed a judgment and that is, there is a LPA
There,
filed
my lord,
by
there
both
one
the
view is
parties.
already taken. Let, my lord, a fresh view be taken. By
No, no,
Karnataka
no,
High
no,
Court or
no.
Punjab High Court.
No, no, let it be.
Because Lordship may
Look,
consider.
I thought probably Punjab and High Court, the disposal rates are very good. Therefore, I suggested Punjab and Haryana High Court.
Lordship,
Their disposal rate is higher than the.
And your lordship can, my lord, considering that this is, my lord, we have held up, my lord, the.
Correct, it's
council,
the SO decided
lordship
expedition.
can request, my lord, the High Court.
Correct,
to
correct,
decide it
has to be
within-
dealt with.
Lordship, rather Madhya Pradesh High Court and Bombay High Court have said that the outcome of the petition will be governed, the results, will govern the results. Other high courts have not even said that.
Now, done,
Only-
we can
but
replace
the
them,
court
take
can,
it up.
Supreme Court can.
This, how much time will it take? 1 day's hearing, that's all.
Exactly, my lord, not one day.
Lordship, Lordship, please, we may coming with folded hands, Your Lordship.
No, no,
It's extremely.
please don't fold that. Why?
Why should
Right to
law,
our-
law students should never fold hands?
Look, it's, if we want early disposal, the convenience of the council should not matter.
No, no, not of the convenience of the council.
I accept notice in transfer petition number 48.
If your lordships can consider observing that it may not The notice, issuance of notice may not mean that Punjab
Yes,
and Haryana High Court
but
may not proceed. And all
we
can
are-
participate.
But no, in the meanwhile, parties may complete the pleadings, notwithstanding pendency of the present proceedings, parties may complete the proceedings. Punjab and Haryana High Court will also continue with the, no, but that will lead to difficulty because others may not be present there. Let it not be. I won't say anything on that. May
We
complete,
can serve their counsels, my lord.
we have given that limit.
Milord, I accept notice and transfer petition number 48, Milord.
Give your,
Number 1.
give your attendance.
Milord, I am from Karnataka, Milord. Lordship will not say Punjab is my God.
We have not said anything.
Oblige.
Video conferencing will be available, but it has to be one high court.
Obliged, Your Lordship.
Oblige.
Punjab and Haryana High Court.
The other high courts may defer the hearing. till-
No, we are not saying anything. Most of the
I
high courts
think it
will
would be-
immediately defer the hearing, specifically when we have said that the pleadings
Prima
may
facie
be
view is
complete.
good enough. Yes, yes, the other high courts would, my lord. Oblige.
There is going to be a guardian, the application, IA number so and so, also you say issue notice.
An application for the appointment of a guardian for the minor.
No, but the person must be, the father, or the
I have no-
father must be representing the guardian.
Yes.
The minor.
Nowadays, minors are our guardians, basically, on the lighter side.
20 we've already
Uh, 20 and 36, we have already issued notice,
That's identical matter.
issued notice and tagged where.
Milords, in fact, Milords, the order your lordships have passed, Milords, is at page 251.
060632.
060
030
030
632 of
6 32 of 2024, Anand Kumar KJ versus Assistant Commissioner on Income Tax and others. Notice will be served by all modes, including Basti.
Milords, your lordships have also indicated, Milords, in the order, Milords, that the order, Milords, the final order will not be passed, Milords, and the issue of limitation can be raised before the AO, Milords. That order is at, Milords, 221, Milords. Page 221, Milords, is the order passed by your lordships.
The proceedings will continue, but
222.
Final order will not, Milords, at page 221.
final order will not be passed by the, till the next date of hearing.
And the assessing officer may examine it.
And Milords, the AO may
The
examine.
same order at page 221
221, Milords,
and
obliged.
222.
Milords, obliged, Milords. And Milords, they all can come together, Milords, because it's the identical, Milords.
Same. Same order in this case.
Obliged, Milords.
So,
Lordships, kindly, if I may just mention, 19 is connected with 38 minutes. Okay.
Same order.
Item 21, Milords, I beg to appear for the petition. Milords, this is a matter which has reached your lordship's concern.
But this right order, what's wrong with this order? There's already, you first invoked the matter has, you went to the Vigilance Commission, that's been referred to CBI, that's fine.
Sure.
And why have second proceedings now?
Milords, today what is happening is since the matter is,
They
like-
filed the charge sheet or no? CBI has already filed the charge sheet?
no, not in this case, Milords, not in this case.
Hey, that's
May
a
I
case.
just point out, the
There's
gentleman.
no question of case segregating and case.
No, I'm sorry, Milords, may I just.
That's
raise-
the right opinion, please. We cannot have multiple proceedings.
No, what I'm saying, Milords, is something else. I bow down to the observations which your lordships are making. This gentleman is facing a investigation, I am told, which is in public domain in regard to disproportionate assets. That was in regard to its erstwhile official assignment as secretary of DPIIT. Now, this gentleman became the chairman of Forward Markets Commission. Now, there was a merger order. That merger order was.
If that's already subject matter of the CBI charge sheet,
That's not there, Milords.
no, please, we can't have multiple
No,
proceedings like that.
it is this complaint is not subject matter of investigation.
What is your complaint
My
about?
complaint, may I just place Milords section, page 34 for a moment.
Multiple complaints on the same issue.
My lord, this matter has not been investigated. It is still pending at the stage of CVO granting sanction under 70.
So that's fine, they are already investigating that, no?
Milords, they are not.
I will look, please.
Yes, sir.
If the matter, look under the provisions of the Lokpal Act also,
Yes,
they have various options.
yes.
One is to do the preliminary inquiry,
I've done.
one is
Direct
to do the, and also they can refer it to a third party.
Yes,
So in this case, because you had already referred to the Central Vigilance Commission, you had made a complaint. Did you not make a complaint to the Central Vigilance Commission?
Lord,
Ask CBI, yes?
I made a
As
complaint.
you have raised it. You
I
can't
made a
deny that.
complaint to the CBI. I made a complaint to the.
And now the matter is pending
And
before the CBI after the
It
Central.
is not pending, my lord. That's precisely what I'm saying. It's not pending. Kindly.
Then we can say the CBI is not going to prosecute. Do you want us to say that?
I am only trying.
1 minute, please be careful what you're saying. Don't say it only for the sake of arguments.
May I-
Once you accept that matter is pending before the CBI, if you make the statement, then we'll record CBI is not prosecuting and will not prosecute.
My lords, it is not pending before the
No,
CBI.
it is.
May I just show from the records, my lords? Allow me to show from the records. It is not pending before the CBI. Kindly see, my lords, page 43.
Yes.
That is the order which was impugned before the Madras High Court.
We are not concerned. Please make a statement saying CBI is not examining the allegation.
Yes, precisely, my lords. Kindly bear with me for 1 moment. Kindly turn to page 44.
Yes.
It is quoted there what CBI has done. Pursuant to the order, may I just read?
Yes.
Pursuant to the order of the Lokpal of India, with the order dated 3/9/2021, the CVC with a communication dated 17/9/2021 has submitted the report of the CBI dated 25/6/2020. The said report is reproduced below. The complaint received from so-and-so limited has been examined, verified. It has been decided with the approval of the competent authority to forward the complaint to the Chief Vigilance Officer, Department of Economic Affairs, Ministry of Finance for expert examination by the ministry with the request that if prima facie the allegations are substantiated, the matter may be reverted back to CBI along with due
They
approval of
already seized of the matter.
this.
1 minute, please.
Yes.
What you have to do is file a writ petition or 482 in regard against the CBI, you get the answer.
May I make that observation?
Yes, please correct.
Lordship, may I make that
We are not
observation?
inclined to interfere with the impugned judgment and hence the specially petition is dismissed. However, you observe that in case the petitioner is of the opinion that the investigation being conducted by the Central Bureau of Investigation in terms of the directions issued by the Central Vigilance Commission are lackadaisical or not as per law, it will be open to the petitioner to take recourse to appropriate remedies as are available. How we will pronounce either way on the merits of the said allegation.
Deeply obliged.
Rising of the next, we'll have to wait for.
Oh, wait, he said, no?
Just handed over when a connected matter came, my lords had passed this order.
Same order. It
Because
does give the list of cases
yes,
in which you or the other side
yes, my lord.
have raised the same issue. You or the other side.
My lord is referring to the issue of whether we should approach the Supreme Court directly or the High Court.
There are other sides which are also approaching.
Yes.
The accused are also approaching.
Accused are also approaching against order framing charges or order taking cognizance. However, my lord, a 3 judges judgment is there, but some doubt had arisen in a coordinate bench, so the matter stood referred by way of an IA to this honorable court, the learned
That's why you were saying, because in some of the orders, one bench has said, go to the High Court also.
only one order is there, I believe.
One
I'll keep those orders ready.
So
But that
whatever it
order
is,
does not look at, does not take into account Manohar Lal Sharma or Girish Suneja.
one minute.
It's a single line.
There is a difficulty in this.
Yes, I bow down, because
Because we are taking away somebody's right to access to court.
that's right, that's right.
And Antule's case, subsequent
correct.
decision is clear.
My lord is right.
This matter is coming up tomorrow.
It's coming up tomorrow, later
Tomorrow.
Tomorrow it's coming.
Oblige, my lord.
Same in the next one.
Next one, my lord has asked us, my lord had heard that matter extensively and had asked us to seek instructions on the bank officials.
Correct, correct.
So, my lord, that is coming up. This can be tagged with that.
When is it coming up?
My lord, the date is week commencing 20th.
20th. List along with specially to appeal criminal number 9381 of 2024 in the week commencing 20th of January 2025.
Oblige, my lord.
CGST Act, but he's not challenging the provisions. He's not challenging.
Well, that's the same problem is happening. Apparently, your lordships have reserved orders in the Radhika
Correct.
matter.
What we have now clarified that they'll follow the Arvind Kejriwal judgment. We'll follow that order.
Very well, Minister.
We have said, Arvind, if they want to arrest, that cognizance, non-cognizance, we are not with you
Very
because of the amendment. All that we have said is, in case they want to arrest, they'll give you reasons to believe.
Very well.
That's all.
Very,
We'll follow that part,
very well.
not in terms of these earlier orders.
Very well, Minister.
Follow that order.
Your lordships are not issuing notice and notice will have to go.
Yes, we,
Very well.
but the order will be in terms of what we have now passed.
Very well. Very well.
Same order Arvind Kejriwal is finished.
I'm obliged. Your lordships are making returnable some.
Returnable in the week commencing 10 February.
Even a bank statement we have filed, my lord. So I
Yes,
got a
Lord,
bank
I'm really
statement from the
thankful to
state
my
bank.
learned friend. My lord, now allow me. I'm the petitioner.
No, just saying.
Lord, kindly allow, my lord, now the cat is out of the bag.
I'm sorry, before anything, I have a preliminary objection. Let me state it, my lords.
Lord,
All along,
can I
their
not, my lord, act
contest
as a petitioner?
was, let me state the preliminary objection. All along, the contest was to the levy of finance charges. The tribunal passed an order taking on record all this and said, if you have any objections to the statements, file it. They did not ever challenge the quantification.
Let us put it. There may be a change in stand and stance because they were going prime facie, because the contract said there will no interest payable.
Absolutely.
When we confronted that such clauses are difficult to accept and should not be, they
I
are.
wouldn't argue on that, my lord.
So the Solicitor General gave up arguments on that and said, okay, I'll only go by the question of quantum of interest.
Right.
So let him argue on that.
Please, my lords. I filed the
Now,
documents.
my
your
lord,
lords.
kindly, my lord, only 3 facts may be borne in mind, my lord. Now, the new document which has come on record, my lord, helps me substantially. Look, there are 30 projects which were going on simultaneously, projects which were being done by the other side. Our termination, we were having contract only for one project. Our termination was that you have not done anything, the machinery is not there, and whatever machinery you have transferred it to your other projects. That's the ground of termination. Now, please take, my lord, his document.
We are not going to the question of termination because that's a 10.
I'm not arguing that. I'm not arguing that. On interest, there is some relevance. Therefore, I'm saying termination, your lordship, I also made it clear. I'm confining to interest and interest only. Now, my lord, may kindly take, my lord, the document which is filed, my lord, as fresh document.
By whom? You or by the other side?
By them, my lord, on the last, on 8th of January. So your lordship may bear in mind, there are, my lord, several projects. It's on record in the evidence of their witnesses Because we have to ask those questions whether you are having other projects or not. They said, yes, we have other projects.
Yes, please.
Now, your lordship, have my lord, annexure AD1.
Yes.
Lord, please see, we further certify. This is certificate of the SBI. The bank charged interest at various rates ranging from 9.20% to 16.50% per annum during the period from 1st June 2010 to 31st August 2018 on the cash credit account, period. Which project we are not, nobody mentions. But now, my lord, this is how the truth comes out. The bank had charged an amount of rupees 135 crores at 135 crores approximately interest on the said cash credit account during the period from 1st June 2010 to 31st August 2018. The details are enclosed with a annexure 2. The details are given, which gives the dates. Now, my lord, very interestingly, according to them, according to the bank, the interest which they have paid is 135 crores. What is awarded in my contract is only 80 crores, which I am objecting. There is no appeal from them that why 80 crores? I have paid 135 crores.
So that's fine. So you should be happy because
No,
that may be,
no,
that will not be again. But
I'll tell
135
you.
they have paid already.
No, I'm sorry.
But that doesn't mean that you don't pay up 80.
No.
If they ask for
Give,
this amount,
give
that
me the last point, my lord. Allow me to have the last point. This is the cash credit for all other projects, not for this project. That has been my case.
correct, but that's
Now,
credit facilities because money is fungible, so you can't say that where the money has gone.
no.
Because your case was you've been asked to pay 1.58%.
1.58 times, which comes to
Correct.
53%,
50,
58%.
That's where because this is less than that, we put it to them. Why is it less than that? Because this is 9.
But, my lord, kindly appreciate, my lord. I am not saying that why they have not filed an appeal. They have rightly not filed an appeal because this is consolidated interest paid in all projects.
Correct.
Yet in my project, otherwise they would immediately say that if I have paid 135,
Look,
why are you giving 80?
Mr. Mehta, this argument will not work for the simple reason. Suppose they could have claimed 100 rupees, they have claimed 50 rupees. That cannot be a ground to discuss.
No. I'm
rupees also.
no, kindly see the pleading, my lord. They have therefore kept the
We will
pleading
not go
way.
by that. Whatever it is, we can appoint, we can do one thing.
Yes,
Subject to the other side agreement. We can appoint an accountant to go into the accounts and certify what is the rate of interest, whatever interest they
I
pay,
cannot have any objection.
let them.
That would be, my lord, fair to the parties. So I don't think if they have nothing to hide, they also should not have
Just
any
let them take instructions on it without prejudice rights and contentions. For our sake, we can also internally do it, because I couldn't understand your written arguments
My lords,
also.
it's very simple, my lord. In fact, I find what the chartered accountant's certificate on which they've gone, it's 5 lakhs less than what I'm due by the
No, but
certificate.
that's fine. Let somebody just examine that, or if you want,
I just want to
they
leave it.
can appear before your officer and give you the details, let them calculate.
Let a neutral chartered accountant.
My lord,
appointed
we'll have a
by
second round of
executive
litigation.
go
If
into
an
this.
arbitration amount has been
Look,
decided.
please,
No, I don't
53 or
want to buy more
58,
than I'm entitled. That is clear.
but 53 or 58% interest is also very high.
No, my lords, it is not. It is at this rate, 8 years, 9 years.
No,
My lord, it will come to that much.
No.
They applied the ratio of the bank. My chartered accountant applied that. And in fact, what my chartered accountant has given me now, and I have
But if a
examined all
neutral
the
chartered
figures,
accountant
I
undertakes
find
the
what
exercise,
our
objection
evidence
is,
was 5 lakhs. My lords, what the bank has said I'm entitled to is 5 lakhs more. I mean, that's only 0.009%. I'm not for it.
concerned with this project.
The bank is giving me the bank certificate. I should have got slightly more, but my lord, there's a 136 on 3 concurrent findings, my lord, sir.
You know, but sometimes one has to weigh into fairness, etc. And if what the rate of interest is it 53 or 58%?
No, my lords, the rate of interest has varied.
Let the
It's over
chartered
a period
accountant
of
do the
8 years. What the tribunal
Whenever the
did,
litigant, my
what
lord,
the
receives
tribunal did
136
was they
argument,
took a ratio
there is
of the
something on merit.
interest to principal for the period of 9 years or 10 years, whatever the period was, based on the evidence which is before, my lords. That is, if I'm getting between 9 and 16.5% a year, bank rates, your lordships know that it will increase by that much in 10 years' time. It's not going to be less.
No.
My lords, it's not.
We understand that. We are with you on that. You should not be out of pocket in the sense that if you paid interest to the bank, that must be paid, they must.
That's it.
There is no difficulty on that. He's not arguing that. Why even protest that? Why is he not arguing?
My lords, in
No,
fact,
let
the
and-
chartered accountant statement is 5 lakhs less than what the bank, but that's immaterial. I'm not going to file an appeal on that. I'm not doing that. But it's a
you didn't file an appeal on 50
findings of
crores.
fact, my lords.
The fact of the matter is the interest component is almost 3 times.
My lords,
Yes, that's a-
I'll ask my lords, how many matters my lords have seen where people will say principal was X and IBC matters. That is the rate. The bank charges at compounded rates, resting quarterly, etc., etc. That happens practically. My lords have seen it in any number of cases.
Give us the name of a chartered accountant.
Well, your lordship.
My lord, Deloitte, my lords. Let it be a
Leave it to your
let it
lordship.
be
I have no name.
a chartered accountant who is beyond any kind of. I don't want an individual because, my lords, the amount being dealt with. Please have someone like Deloitte or whoever else, my lords.
Yes,
I
your
say Deloitte off the
lordship's
top of my
wisdom.
hat.
Your lordship's wisdom. I don't want to give any name. It's a Bangalore-based company, but my lord,
Deloitte is in Bangalore. I want a big. I want somebody, my lords.
any, my lord.
Because I want to finish this matter once
Absolutely
and for
no
all.
choice, my lord, on that.
For 5 big companies, one is Deloitte, one is PricewaterhouseCoopers.
Pricewaterhouses.
Uh,
Today not.
What are the other two?
Ernst and Young is there. Who else?
Yes,
Ernst,
that is one.
PMG.
KPMG is there.
They are all, who has a conflict? Just find out from your clients if any of them are your clients
They're
or
not your auditors.
Exactly. That's what I told them to find out. That make sure none of them are your auditors.
Internal or otherwise statutory.
I just don't want a conflict. Because then we get delayed. But my lords are. But your lordships are keeping the matter before my lords. Yeah, because I don't want another line of litigation stuff.
He can't exercise 136. Obviously, he is only assisting them.
Come on, quickly. Where are they? My lords will. KPMG, I think there is.
We go with Ernest and Young. We deem it appropriate to.
Would your lordship
Call
think of
upon.
Deloitte? I'm just saying this offhand because they're much quicker. I found in other matters. That's why I'm saying this. Otherwise, I leave it to my lord.
Do you have any difficulty with Deloitte?
We have no difficulty
Yeah.
with anyone, my lord.
I'm giving the suggestion because I
It was
found
not given by your side.
Deloitte you've never had any relationship with. No.
KPMG we handled.
KPMG.
With KPMG they had a.
Okay, we make it.
No,
they had a relation. Yeah, Ernst and Young or I do not know. That's not.
If they have no association with Deloitte, makes
You had nothing to do with Deloitte.
Yes.
No.
Or-
I
or
don't want any.
the lordship
My lord
can-
will appoint Ernst and Young because they say we are not sure. I don't want to.
In view of the peculiar facts of the present case and without prejudice to the rights and conclusion of the party, we call upon Mrs. Ernest and Young Chartered Accountants to examine the question of computation of the finance charges as awarded with reference to the finance charges stroke interest paid
Project in question.
by Navyo Engineering Company to their bankers. Full stop. while carrying out the said exercise, it will be open to Ernst and Young to ascertain whether the interest paid by the respondent, Avyog Engineering Company, could be bifurcated, divided project-wise. And in that, if that is correct, then compute the.
Mara, it
interest
is
paid.
not bifurcated project-wise.
If it is possible to bifurcate it, possible.
If
No,
it's
but-
possible.
No, my lord,
Because I
it's
have a
ministry-
cash credit account which I use for all my projects. So the bank
That's
decides
the
what is it.
problem. That's
No,
the problem.
Bob, it's like this.
They can
1
always.
minute, 1 minute. Then now let me tell you how the income tax department functions. They say if you take money on interest, you can use it for different projects. It's for you to decide. You will not bind them.
Correct, my lords, but
Please.
I'm not income tax department, but I
No,
will
no,
not
please,
pay for.
please. It is not, it cannot be done project-wise.
No, but
It will be impossible for them in this. Look, and then your cash flow.
Possible project-wise, your lordship may say.
It is
No, no,
fungible.
if possible. I've
If
said
possible, project-wise, your lordship.
possible.
My lords, if your lordship says that, then the whole argument will go.
No, 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 if possible, I've said.
No, why
Look,
would you be afraid?
No, no, one.
I'm
one
not
moment.
afraid, Mr. Mehta.
In your
about
favor,
the
I'm saying,
finality.
in your favor, I'm saying also this one, because in case the money had come to you earlier, obviously you wouldn't have taken even money for the next project.
Yeah.
You would have compensated.
This project never kicked off.
No, the money
used it
becomes
only for
fungible,
other
my lords.
projects. That's our main,
If
termination.
possible, I therefore said project-wise. The data and details will be with regard to available with the petitioner, and the respondents will be furnished to Ernst and Young, Bangalore, with a period of 3 weeks from today. So in case they require any, in case there are any questions and issues, the same would be given to the petitioner, and the respondents will file the response within 7 days from the date. Question is.
Or my lord, both of us may assist them, so that,
Questions are raised.
my lord, without
required-
assistance,
if
my lord, going
required-
by numbers would be a
1 minute,
difficult
please.
proposition.
If required, no, you'll have to answer whatever it is.
No, no, certainly. So we will be there.
If
to assist,
required in
that's all
this
I'm-
way, the Ernst and Young may ask the responsible, the responsible officer of both the petitioner and the respondent to join the proceedings. Report would be submitted within a period of 8 weeks from today. So cost, initial cost for the cost stroke fee of Ernst and Young, which are quantified at rupees 5 lakhs, will be paid by
By
the
them.
petitioner.
Please, your lordship.
My lords have said, verify the data given by the respondent.
Both, you'll give the papers, both of you may give the papers.
Well, look, they won't have anything, by the respondent.
I've asked them, both you and them, both of you have to give the papers. Whatever they have, they'll give, whatever you have, you give.
They didn't produce any paper.
1 minute, please. Before the arbitrator, you must have filed the papers.
Yes. We have,
So they, whatever papers are available with them, they'll produce.
they did not file anything as yet, nothing. Because, my lord, naturally also, because they did not pay the bank the interest. So
One
we have no
minute,
papers.
how will they know your financial arrangement? They will not know.
Absolutely. So
Correct.
they have not filed anything
So,
for me to
but
prove.
they can file the papers
We
which
can
are
also
available with
file,
us.
my lord. Why? It can be
I'll leave
ignored
it.
by us.
My lord's giving a date, my lord.
Relist in the week commencing 1st of April 2025.
My lords, please. Not a very opportune day.
Doesn't make a difference. Dates don't matter. Next case, please.
My lord, next, my lord, if your lordships can have it on Monday, I couldn't go through. It's a transfer of case from one cat to another, but there are some issues.
only.
Last time you had said agreed to,
Yes, I agreed to that transfer to Delhi, my lord. If it is the original application
you
decided.
please take your instructions.
My lord, then I have no
Delhi,
issue.
that only question was,
Short.
they transferred to CIT Delhi,
Can it be kept day after tomorrow, Friday?
right?
Okay.
Right. Both the matters.
Yes,
Let it be on Monday then, if my lord.
Okay, Monday.
yes. Wait, is it all?
Still with what whole block matters.
Lord, on the last occasion, your lordship noticed that we had
They
filed
come
that
up,
this-
let it come up tomorrow.
Tomorrow.
Lord, the difficulty is that on merits, I have not been heard at all. so far. We want to stay, my lord of the, so if your lordship gives me 2 minutes.
There is a question of stay. Trial will take ages.
No, trials these days, my lord, in these PML.
No, no,
don't
mister.
take very long.
No, no, it will take a long time.
I wish
Lord, someone has to hear my case because
No,
according to
we'll
me,
hear
Lord,
you,
it's
we'll
an
hear you.
absolutely clear case. I can't go to the High Court because of those judgments. Your lordship is, my lord, deciding as
We are considering where there appears to be, have been also a reference to three judges bench, one of the benches.
true, my lord, but that is only on the issue of
Which-
whether I come
which
here
are-
or go there.
Look, under the law also,
Yes.
normally stays are not granted. Even if it is a debatable issue,
Yeah.
even if it is a debatable issue, let the trial continue.
I fully agree.
Consequences of stay are much more.
I fully agree that, my lord, normally a stay will not be granted, but according to me, this is such a clear, at some stage, your lordship may give me
We'll
5
see that, we'll see that.
Lord, one request. The online appearance today is not working for the OR code. Can I?
Okay, give it
tomorrow, my lord.
tomorrow.
Great.
With this matter, there's another. That also may be had tomorrow, perhaps coming up day after.
Okay, we keep it day after tomorrow then. We keep it on day after.
This matter is coming up tomorrow.
No, no, I know, but that is.
No, the
The matters are coming up tomorrow.
Whole batch is here tomorrow. That whole
The-
batch, my
the
lord.
batch is coming on tomorrow, my lord.
Only two IAs are listed. IAs and all those matters are
Decide as
listed
to
tomorrow.
whether one should go to the High Court or, my lord.
People
directly
want
here.
clarification of that earlier
That's right. So
judgment.
that batch is listed tomorrow. Therefore, your lordship may
I
have
thought only applications are listed tomorrow.
Only application.
clarification as to whether you should be able to go to the High Court.
Okay, come, let it come tomorrow.
Lordship,
But we are not listing any more matter tomorrow. Let the other matter come up day after tomorrow.
lordship, please. So our matter, my lord, where notice has already been issued tomorrow. Lordship, please.
This can be disposed, this is to be it's already
Yet only one matter remains. The plan was. No, this Kishore Parekh is.
The proceedings against Kishore Parekh,
B. Parekh.
Kishore B. Parekh in the present contempt proceedings will be treated as closed. So motive contempt proceedings will be treated as closed.
May I please? May I please?
There are a number of reports which have come.
May I just give a brief background, my lord? Your lordships are hearing it for the first time. My lord, in 2015, your lordships gave a direction, my lord. I'm so sorry.
Bench presided over by
Very well. Great. Lordship would give some date, my lord, whenever.
List in the week commencing 10th of February 2025.
Great. Please, your lordship.
We asked for is not, sir.
Lordship.
National testing agency. No contest being held.
Lord, there are
My lords, since the year 2021, different batches of students who have been appearing for the NEET PG exams have been filing different petitions. In essence, their grievance is one.
Who's R4?
National testing agency.
R4 is National Testing Agency. Your
Those,
Lordship.
anybody
National
appearing
testing
for them?
Yes, I appear for them, but they have no role, Your Lordship.
in this matter, they have no role. Lord. I just wanted to inform your lordship, there is a batch which is otherwise coming up before my lord Justice Gavai at item number 60. Today.
My lords, I'll tell you the problem with that. So we had also filed a different petition, my lords, in the year 2022.
So
But
they
these are
can
group-
go before one bench, it will be.
My lords, all of those, including in my petition, the earlier petitions have been held to be infructuous, and most likely the petitions which are coming today will also be held infructuous. We have filed a Article 32 petition in the form of a PIL because these clauses which are problematic are being repeated year after year in the same way. I just want to show 2 pages and 2
No,
clauses.
let that, we first wait for that judgment, there after that we'll go. Let this be also listed before just.
My lords, then this may be listed tomorrow, my lords.
Not so fast, not so urgency.
Because, my lord, in that
There's
case,
already an interim order passed, after detailed interim order passed.
my lords, my only request is, in all those petitions, the petitioner have already passed out. They've already taken a seat.
Correct, correct.
So this is the only standing matter.
That's a, your case is of a bigger,
Yes, my lord.
larger perspective.
Yes, my lord.
Right up. Left before a bench presided over by Honorable Mr. Justice B.R. Gavai, who it is stated is presiding over the bench, hearing matters relating to the
NEET PG 2024.
NEET PG 2024. Stop. List in the week commencing 3rd of February 2025.
Grateful, my lord.
Yes, please.
Minute, please, Lordship. The short issue that I.
How can the last, you are paying for the, how can the last direction be issued? At page number 6.
It should be given for the state, huh? Then it should be given to him.
How can the last direction?
And it's because for the simple.
And 1 minute. No, it cannot be. You can't go. If they find that the fresh tender is given is lesser than the earlier tender, what?
No.
They can do it.
May I with respect say?
Why not? Public money is involved.
Just-
The last directions cannot be certainly issued, Mr. Paul.
Yes, that you give it to a person. But after that, the L1 after that, they'll consider as per rules and decide.
1 minute. The other thing is whether if they want to cancel the contract and award a fresh contract, normally court will not interfere except ask for the reasons why they have done it.
My lords, would your lordships just hear me for 2 minutes on these 2 issues? I am for the affected party. Please hear me. One, the petitioner before your lordships is not the state. The petitioner
not
before your
He's a successful bidder in the
No,
second option.
just a minute. He was disqualified in the first tender. What is only being challenged is the cancellation of the first tender.
Correct?
There the state says in that writ petition, he is not even needed as a party because he was disqualified. It's only about wrongful cancellation of the first tender.
1 minute, Mr. Call, that's not the way we look at things. We can't put the first tender into a watertight compartment and the question is because he's a successful tenderer in the second one or he.
But for the respect, then your lordships must, then your lordships hear me.
No.
I address on that, my lord.
May not be, the necessary and proper parties have to be understood.
That's all right, but hear me.
And
at
we
least
will not,
on the merits
we
of
can't
the
outstay
impugned
our
order.
focus. We
No,
can't.
on the merits of the impugned order.
Correct, we will.
Yes.
Just, you're appealing for the state of Odisha?
No, yes.
Now, what is the reason why you cancelled the first tender?
I'm told it's on a commercial consideration. Now we have got for a better price about 8 crores.
So can you just show us that reason, that's all?
I'll give.
Your counter affidavit doesn't say so. Before the High Court also, you don't say so. You just had to say what was the reason why you cancelled the first tender. Maybe you failed that the number of tenders who had applied were less. That can be good ground. Or you failed that there was some.
Well, the ground the solicitor is now given is a ground never taken either in the minutes or in the counter affidavit file. The only
Just
ground.
produce the file.
I will.
Produce the file, that's a very short issue.
That's right.
And if you make if you want to go ahead with the same tender, or now you'll issue a fresh tender?
A fresh tender. That's it. Now in the fresh tender, he was a successful bidder. By which
Now, I'm asking you another question. Will you go for a fresh tender?
altogether fresh tender.
Or you want to go with the second tender?
Yes, I'll get instruction on that. Otherwise,
If
as
it's
of
a fresh tender, then both of them may stand aside and say, okay, let there be a fresh tender.
I'll get instruction by.
There was a fresh tender and respondent chose not to.
I'm talking about because now the time gap has taken place, your rates will not be relevant today.
Your Lordship.
Your rates will not be relevant today. Today's rates will also not be relevant.
I'm still happy to do it at those rates.
No, you don't. We
As
will
I
not.
said, my lord, without the lapse
Mr.
of time, I'm still happy to.
Mr. Call, let me put it very clearly to you. There is no question of the court directing any authority to enter into a contract at this rate. One. Number two, the court, the authorities have the right to close a particular tender and issue a fresh tender, and also issue a fresh tender. Only they have to give the reasons. No, one. Number two, court will not examine the merits of the reasons, and the laxity and the difference which is shown is going to be huge and substantial, except when it's on exercise something which is.
In any case, we'll keep our powder dry for that. According to me, your lordship's judgment says the reason has to at least meet the test. That is your lordship's judgment. If there is no reason or contrary to record, it's not your property. It's not your personal property. You hold it in trust as the state. Is what your lordship.
What else is required in this case? The second tender, the prices fell down.
No, my lords, may I with respect say, let me address your lordships on that whenever your lordships hears it. That we'll address your lordships on that.
In any case, please take instructions whether you want to go for the.
State come with
In
instructions.
case you want to go for a fresh tender
I'll
with the
get
passage of time, you better,
Yes.
then this matter is infructuous.
Yes, I'll get instruction on both the aspects.
The additional solicitor general appearing for the state of Orissa will produce the original reports before this court on the next date of hearing and will. Go for fresh tender in view of lapse of time.
Would your lordships have it on Monday, my lords, because this matter has been pending. Would your
Relist in the week commencing 27th of January 2025.
Grateful, my lord. Very great.
Thanks, sir.
Admiralty matter.
Led by Mr. Sundaram, your lordships may kindly pass over.
What has happened now?
The Admiralty matter, as per the order of this court, they have furnished bank guarantee, vessel sailed the same week.
So now it can go back to the High Court.
Yes.
Your lordships, one issue that needs to be determined is whether it goes to the commercial division of the High Court or the, so your lordships may kindly pass over the matter.
In my objection,
Court, the High Court is of 2017. The High Court, the Admiralty Act is of 2017.
came into force in 18.
It came, but it's later in point of time as compared to the Commercial Courts Act.
No, nothing.
Yes, your lordship.
Commercial Courts
Law
Act is
Commission
earlier.
report, Law Commission report, Parliament debate, legislative, and then the object of the act. Nowhere Commercial Act is mentioned.
So may not be mentioned, but the Admiralty is subsequent on point of time. How can you say Admiralty says High Court now?
Yes.
Then are you saying Commercial Division of the High Court?
No, there are 5 courts having commercial original jurisdiction. Other high courts like Karnataka, Orissa, and Kerala, and some more high courts doesn't have commercial original jurisdiction.
May not be having, but once the legislation has passed the Admiralty Act in 2017, saying because it's judgment in rem. First part is judgment in rem, then there's a judgment in personam. So if it's a judgment in rem, in that case, it has to be passed by a constitutional court. There's no difficulty in that.
But you can direct. Lord, one more thing, Lord, I have in Annexure R1, 5, Lord, I have produced a comparative study of all the high courts. The commercial court jurisdiction, how the nomenclature is there.
Let him come, we'll see if
Yes.
we can dispose it of.
Wherever, my lord, commercial.
Because otherwise the vessel is sailed, so today this matter is infructuous. As far as interim order is concerned.
And my lord, this commercial, applicability of commercial act, that was not taken below the court below.
So it's been dealt with by the impugned judgment.
Yeah,
It
Not
has been
even
dealt with in the impugned judgment.
even the division bench also rejected that. Being a constitutional court, lordship
Lordship,
can
the
intervene.
impeachment judgment records our objection. It has been taken.
It has been taken.
It has been taken.
Here,
Your lordships are passing it over?
okay. By your second call, none appears for the petitioner. In connected matters, we have passed the following order. First of all, if the petitioner wants, he can avail of the said remedy. According to aforesaid, the special leave petition is dismissed in default. Yes, please.
Your lordship make to the page 88 of the,
Yes.
in clause 5 of the tripartite agreement.
Yeah, how much was the delay in making your claim? 1,700 days. And what is the stand?
Your lordship,
The stand is you had given the loan primarily to the landowner, nothing else. Sorry, to the flat buyer, nothing else.
your lordship, but the clause 5 says that the.
No, sorry, it's only in case of default, sorry, nothing more. We do not find any good ground and reason to interfere with the impugned judgment, and hence the appeal is dismissed. 18 and 37. Now tell us one thing.
Yes.
The candidates who participate in the election,
Yeah.
they're entitled to that document or not?
No, because from the date, without opening the pages, under various handbooks and circulars of the EC, you can get video, CCTV, 4 documents in particular. Just
No, there are two aspects.
now, what happens with this
That's what-
amendment?
Let's have some clarity on that. Dr. Singhvi, one is any third party applying, for which he has to pay the charges. Second is where the candidate who stood in the election applies.
So let me answer that.
In that event also, he's barred from taking the.
Yes, yes, the amendment is to the rules, saying that unless I specify in these rules, I am not obliged to disclose.
But
now there is no specification under these rules. The amendment is a one-line amendment under these rules. The specification earlier, when your lordship used to get it, of these very important documents, 17C, voter form 20, was in other
Which
documents.
page?
No, I've got.
What's the earlier rule?
Yes, kindly see this. That's the catch in this. They've done it very cleverly. There are no earlier rules. This is the way it used to work. Kindly give it. And then see the amendment now made. Now, just give me, it take 2 minutes only, supply of CCTV footage of the entire was under clause 19.10.3 of the handbook. Supply of the result sheet was
what does the handbook read?
Handbook is what is quoted here, on the left side. Left side. Then next was copies of result form. Imagine, even this. And the third is supply of 17C, which is an account of votes recorded in favor in each constituency. Now,
this account of votes in each constituency may be slightly maybe problematic.
Now,
is
all
it
three.
Booth-wise? Is it booth-wise?
These are all booth-wise.
No,
Originally, it's booth-wise.
Will it not reveal how the particular?
No. Now, this is one of the reasons given in the press is that we have taken away CCTV and video because it is revealed. But does your lordship ever get the identity of what I vote when I go behind?
I didn't ask that question when it came to that. I didn't ask you that question when it came to that. But when it comes to constituency-wise, then it may lead to a problem.
Well, may I answer that? Because I fought the election, Maharaj. The 17C form is given.
I thought both of you have fought election.
No, in the Lok Sabha. 17C form is given in the Lok Sabha. 17C form gives to each representative of the political party. He has to sign the 17 form. How many votes have polled?
That we are aware. We dealt with it in electoral.
Correct. So that is available. It is otherwise available.
And see,
it is otherwise available, Maharaj.
And see the amendment. It is a very clever amendment.
1 minute, please.
Yes.
70C is otherwise available, Maharaj. It's with every polling
but that will not reveal which way the courts are.
Cannot.
Exactly. That's
cannot under any. And 28 is the amendment, a very clever amendment by one line. Over clever by half.
returnable in the week commencing 17th of March 2025. Notice to be served by all modes, including dusting.
Your Lordship will give a direction. On that day, they will come and say reply, rejoinder. This lot of time available now.
Will file.
Let them file a reply before that.
They will file.
Constitutional authority. They will never file. They will come and seek
They
time
will
that day.
file.
They will seek time that day. No, Delhi action. Nothing will happen. Next week. Much.
Yes, please. Now, the only question which remains is with regard to the jurisdiction, whether it's Admiralty Court,
Because
the High
your
Court.
lordships directed me in the meantime to.
You have done that.
I've done
ship
that.
has sailed.
Ship has sailed.
So
But this
now the
question
other
is of great.
issue, the other issue will be decided by the merits will be decided by the High Court.
High Court.
Now the issue is who's to decide, the High Court or the
Commercial court. This
Now,
is the
please
point.
argue on that.
And that alone I will place before my lord. I just request your lordship to give me a. Well, since it's a pure question of law, your lordship will just permit me to take you through those sections, because this says some, because other courts also exercise admiralty jurisdiction. What I have found is that apart from this particular court, almost all other courts have a commercial court to deal with it. So far as courts with ordinary original jurisdiction is concerned, the issue is not a problem. It's courts where there is no ordinary original jurisdiction, what happens? That is where, because then the ordinary my whole point here is where we are missing the woods for the trees is the High Court, even courts which don't have ordinary original jurisdiction, are conferred an ordinary original jurisdiction in admiralty cases. This is the whole difference. The whole reasoning seems to be that it is the district court which has ordinary original jurisdiction. High Court doesn't. So there is no commercial division in the High Court for the purpose of ordinary original jurisdiction. The answer is this: if the High Court does have ordinary original civil jurisdiction qua admiralty, surely there must be a commercial court for that purpose. Under the Act, the High Court has to have a commercial division. Now, courts like Karnataka feel that they need only an appellate commercial courts division because they have no ordinary original civil jurisdiction. So it.
Sundaram, the argument doesn't appear to be correct. Normally, it's a fault of the High Court, let me put it, because the High Courts have to designate a particular commercial court within their jurisdiction. Karnataka High Court may not be having original jurisdiction, so they have not designated any commercial court.
They have a commercial appellate division.
Because they'll
hearing appeals.
They will be hearing appeals, correct? So they'll be having, obviously they'll be having commercial appellate division.
For arbitration, they have a commercial division. To hear arbitration.
No, for arbitration, they have a commercial court?
Yes.
Commercial court?
Yes, yes. I'm just passing that on to my lord.
So that judge can hear this matter. Then that judge can hear this matter.
For arbitration, they have it.
Then.
Because under 37.
No. In Karnataka, do you have commercial court for arbitration?
Best of my knowledge, no, my lord. Only
and pass the circular to my lord. Please see the circular.
16 of the Admiralty
The Honorable Chief Justice
High
on
Court
24th.
says there is no rules, there is no commercial or.
No, 1 minute, please. Does Karnataka High Court have commercial court for arbitration?
Yes.
To best of my knowledge, no, my lord. I shall
Look at
once
that
again.
circular.
My lord, I passed the circular.
Look at that circular.
I just passed you a copy of the circular. The Honorable Chief Justice has ordered that in view of Section 2E2 of the Arbitration Act, a challenge to an award in an international court of commercial arbitration can be made before the Honorable High Court of Karnataka. Accordingly, has constituted a commercial division under Section.
Commercial division?
No, it's a single judge.
It's a single.
Yeah. Of the Commercial Courts Act, consisting of single judge at the principal bench at Bangalore and benches at Dharwad and so and so. Proceedings filed under Section 34 of the arbitration as regards challenge to an international commercial arbitration before the commercial division shall be classified as COM.S. So they have a judge.
Let the judge hear the matter.
No, my lord. It's a order of 2022. When I filed the admiralty suit, initially as per us, we file in other high courts. When I filed the admiralty suit, the registry corrected it because we don't have a original admiralty jurisdiction.
So 1 minute, please.
Pardon, my lord?
1 minute. The Commercial Court Act says it will apply to admiralty suit.
Yes.
I'll come
1
to that.
minute, please. It does. 2M says it will apply. Non-harmonious reading, it will mean that each high court with, because the Commercial Courts Act also has very stringent provisions with regard to filing of written statement, disposal of the cases, and that's in the interest of general public, in larger public interest, not general public, public interest they've done that, because commercial matters, if they get delayed, it has impact on the economy of the country and the state itself. So in harmonious reading, the High Court will deal with it, but the commercial division of the High Court of single judge will deal.
It's not there. Lord, that has to be notified by the state with the consent of the High Court.
They will better do it. They will do it. It's not to be notified by the state, it's to be notified by the High Court.
By the High Court.
It's not to be notified by the state. It's to be notified by the High Court.
Yes. And it has not been done so far.
No, they'll do it.
Even in Orissa, even in Kerala.
No, they should do it. Maybe they have not done it because they will not, this question.
My lord, R15, may I take your lordship to R15, my lord?
May not, even if it has not been done, it's because of maybe lack of awareness, that's all.
But that doesn't mean that my present suit has to go to the district court.
No,
Because
it will
Not district court.
We are not saying it's
I'm
going
not
to
saying
district
lord,
court.
they want the matter.
No, we are not saying no.
No, even I'm not saying that. I'm saying.
Before the single judge and division bench, single judge, it was not raised. Before the division bench, they want the matter to be filed
It
as
is
commercial
submitted,
suit.
1 minute please. It is submitted on behalf of the petitioner that in view of the Commercial Courts Act, which year?
2015, Commercial Courts Act.
2015.
And section 213.
C. In terms of section 21C.
213.
21C3.
21C3.
21C3. Roman 3. All issues relating to admiralty and maritime law have to be heard by a commercial court constituted under subsection 1 to section 3. So stop. Even when section, what's the section of the Admiralty Act?
12.
When section 12 of the
Admiralty Courts Act, DC
Admiralty
page
Court Act
314. I'll just show you, Lordship, the exact section.
Lord, jurisdiction is section 3.
Section 3
Lord,
of the Admiralty jurisdiction. Page 315 of
no,
the.
read all high courts. All high courts can exercise admiralty jurisdiction. Then come to section 12. CPC is applicable.
Okay, 1 minute. Section 3 and 12 of the Admiralty Court Act 2017 states that jurisdiction in respect of all maritime claims under the said act will rest with the respective high court. Subsection 12, let's come to section 12.
12 of the Admiralty Act.
It also state that provision.
The application of CPC, my lord.
Yes, but CPC as amended by the Commercial Courts Act. CPC as it stands.
No.
It's been amended. Chapter 3, my lord says.
Section 12 states
That does
that
not come into play with Admiralty Act.
provisions of
See this,
Code of Civil Procedure 1908 will apply to the proceedings before the High Court.
If your lordship sees provisions of CPC like at page 302, please see order 11.
3, don't, section, C and 3 and 12, just refer. Section 12 of the Admiralty Court Act says that the provisions of the Code of Civil Procedure 1900 will all apply before the High Court. So far as they're not inconsistent with and contrary to the provisions of the Admiralty Act of 2017 and the rules made thereunder. Full stop. Our attention is drawn to circular dated 24/2/2022, whereby commercial division of a single judge has been constituted for the principal bench at Mangaluru and benches at Dharwad and Kalabugi in the state of Karnataka by the High Court of Karnataka. How it is pointed out that the High Court of Orissa and High Court of
Karnataka.
Kerala
Kerala.
have not constituted any.
Gujarat, however, has a commercial division.
Huh?
That's the strange thing. Gujarat High Court, even though they have no ordinary original, have a commercial division for Admiralty.
Lord, Gujarat, Bombay, Madras, West Bengal, wherever the original commercial jurisdiction is there, the suit is filed under the Admiralty Act and CPC.
Not under the Commercial Courts Act.
There is no provision in
Sorry,
the
my
Commercial
lord.
Act.
My lord, my
There is no
learned friend
provision
may
to
not be
arrest.
right.
There is no provision to arrest. The only
My lord,
word, Lordship, what they used is, the word used is 31A is married.
No, look, normally we would have liked to read the two provisions harmoniously and say it will be maintainable before the High Court, which will mean the commercial division of the High Court of a
Can be,
single judge.
Lordship can direct.
1 minute, normally. But the difficulty is coming up because of section 12. Because the moment we say so, in terms of section 12, now the provisions of CPC applicable. Now the Commercial Courts Act says certain provisions of the CPC will not be applicable.
No, my lord, I have to correct that. Just a moment, my lord.
Even in
The
Commercial Act.
CPC has been amended.
No.
Where, please take page 302 is just an example.
By the Commercial Courts Act.
No, my lord. The CPC says, my lords, by order 11 of the code, the following order shall be substituted. My lord, this is substitution brought in the CPC by the Commercial Courts Act. So when you say CPC section 12 will apply, it will be 12 as amended by the commercial. There's actually no dispute here. That's why I pointed out 12 to my lords. Please see. I think it's made clear at page 291. Just read that with me, my lords. I think that will be clear to my lords. Page 291, I've kept the Commercial Courts Act and 291 of my paper book. That is, my lords, of the application for additional documents. We have filed the Commercial Courts Act. It's the application for additional documents. And kindly say page 291 is the act itself.
Yes.
There is really no problem here. If you just see.
Just one.
At page 299, please see the schedule to the CPC. Please see, first see 297, paragraph 16, section 16.
Yes.
The provisions of the Code of Civil Procedure shall, in their application to any suit specified in the commercial dispute of a specified value, stand amended as in the manner as specified in the schedule. So therefore, my lords, this falls under 321C3. So it will stand amended in the manner as specified in the schedule. Schedule, your lordship, finds at page 299. It's not that in commercial cases, CPC
What
does not
you're
apply.
saying is in terms of section 16 of the Commercial Courts Act, it's a CPC which is amended.
Yes. And what happens, my lords, is in all commercial cases, it's not that the Commercial Courts Act gives you its own formula. They make the CPC applicable as amended.
But there are also provisions which say that the following provisions of the CPC will not apply.
Yeah. My lords, kindly see. I'll show your
That's
lordship
what-
the section my lord is referring to. My lords will kindly see, 16 says, amendments to the code of, can please read 16 with me fully, my lords. The provisions of Code of Civil Procedure shall, in their application to any suit specify in respect of a commercial dispute of a specified value, stand amended in the manner.
But there's, here also we should be with regard to 12A.
So when we say section 12 CPC applies, CPC as amended on the date of the
Our
suit.
attention is drawn to section 16 of the Commercial Courts Act 2015 to submit that the amendments by said section are made in terms of are made to the Code of Civil Procedure itself in terms of the schedule. Full stop. In other words, the Code of Civil Procedure as amended by the schedule will be applicable. Full stop. Next page. Be informed that commercial divisions have not been formed with regard to admiralty cases in the state, in the high courts of Orissa and Kerala.
Which page is that?
May I take your lordship to the
In fact,
objection?
if your lordship would find it of assistance,
One.
if you would find it of
Prime
assistance,
Minister,
page.
we are of the view that the matter will go to the High Court, but commercial division of the High Court.
Yes.
Because that will be in
And my lord, there may be also direction to frame rules.
Before we pass appropriate orders, we deem it appropriate to issue notice to the High Courts of Karnataka, Kerala and Orissa.
Any other courts which have not formed it?
No, on this point.
Gujarat has a commercial division. Orissa has not, right? Gujarat has not.
To ascertain their views, of notice will be served to the Registrar Generals of the High Court.
Can I, just to assist my lords, you might find it of assistance, my lords, page 163 of the counter of R1, there is a whole list of every court and what they do. It's at page 163. That's just for assistance of your lordships. It's page 1. No, this is your document. I'm relying on your document.
It's your lordship.
But you are right.
Lord, in all high courts, even though there are commercial division, the suits, admiralty suits are tried under CPC.
No, maybe tried under CPC as amended by the commercial courts.
Only the nomenclature. Nomenclature is given in some courts.
1 minute, please. As far as nomenclature of commercial suits is concerned, you have to mention on the top itself it's a commercial suit.
Let me take your lordship to one.
My lord, the sting is in the tail. Can I say where?
Lord,
1 minute, please. Yes.
in Maharashtra, Bombay,
Sure.
Even though they have a commercial original jurisdiction, it is filed as a admiralty suit under CPC and admiralty.
Not under the Commercial Courts Act.
No, my lords. Commercial suit, page 163.
Only the
not a-
nomenclature.
No, it's not treated as a commercial suit.
No.
It is. Please see page 163. It says commercial suit, nomenclature of admiralty suit, commercial suit. And filing is done in the commercial division. This is my learned friend's document. Page 63,
wrong on that.
163.
I agree that because it is filed in the original commercial division.
1 minute, please. We have understood that. The only thing we are asking is, in other courts, in other high courts, when you approach the high court, the matter is listed before the commercial division
Yes.
of that high court.
Yes.
Yes.
All judges are not designated as commercial division of the high court. They keep on changing, notifications keep on coming, which judge is to be functioning and as per the roster will be performing functions as the commercial division of the high court.
Yes.
Relist in the week commencing 24th of March 2025.
My lords, may I give notice, my lords, to the Standing Council of the States? That might be quick.
The notice will be, no, they'll be able to send a notice.
My lords, the states involved, because so far as Madras, Bombay,
One minute.
Calcutta are concerned.
We also deem it appropriate to issue notice to the Attorney General of India, who will obtain his, who will appear in the matter. I know, give assistance. Because there is a ambiguity, they should have said, in this case, the amendment, when the 2017 Act was there, it could have simply said commercial division of the High Court.
Absolutely. There is a ambiguity.
In the section 12, they could have said as in terms of the commercial.
But I'll have to take it this way, because when they say
You are-
CPC in section 12, on that date, it was already
Yes,
amended.
We have understood that argument, but that argument was not required to be raised
Absolutely.
in case it was said in terms
Couldn't.
of, or in, as amended, or in terms of section 16, the railway schedule of the Commercial Ports Act 2015. That need to raise that argument and consideration of that argument is taken away.
In fact, my lord, on a lighter vein, if legislature was so precise, people like me would not have
No.
anything.
This registration should be so precise. This is not very difficult.
Lordships, please.
Yes.
May it please your lordships. Lord, I appear in SLP 10599. SLP 10599 of 2024.
Yes.
I represent C category of Lord employees who have been appointed. And we are now, my Lord, in the clerks category, my Lord, we are now all en bloc asked to leave under the judgment of the High Court. Now, my Lord, there is no doubt that if there are irregularities, then, my Lord, one must be asked to go. It's very well, my Lord Justice Sawant once put it brilliantly, that if you enter through back door, you must be prepared to go through back door. So, my Lord, there is no doubt about it. But I'll be able to demonstrate to your lordships that there has been no serious inquiry here to go into the aspect as to what are the nature of the inquiries.
Just one minute. There's one more matter relating to that intra-court appeal issue. I don't think this matter will be over. So you may please, maybe not next week. Keep it after some time. Probably we'll list it in March, but I don't think this will be over. This one is partnered and there's so many people involved in it. In item number 35, you said, not possible to take up the matter for it. It has not been possible to take up the matter for hearing. The case for hearing relist in the week commencing 24th of March 2025.
May it please your lordship, I am so sorry to trouble your lordship. This is Advocate Nedumbara. I am making this request, my lord, since I am facing dispossession. The Bombay High Court has directed demolition of 80 flats.
Not like this. You can't.
My lord, 80 flats without notice.
Mr.
Yes.
You're in council, you can't interject like this when the mark.
I'm so sorry, my lord. They are coming to demolish.
Move an application, it will be listed tomorrow.
It has been moved. They are come to demolish the structures. Around 80 workers, 80 families are involved, and orders are passed without hearing us.
It will be listed tomorrow. That's
tomorrow.
It's the third week of March, fourth week of March, sorry. Fourth, नहीं वो लिखने की भूल Next case. Yes, please.
Yes, ma'am. So, my lord, here is a case where, my lord, there have been no serious inquiry or investigation by any, my lord, independent committee. Madam Courtmaster, there has been no serious effort, no actual inquiry to go into the actual aspect of the irregularities. Everything has been, my lord, said on the basis of this so-called, my lord, material which has been, my lord, received from this Pankaj Bansal, which CBI claims to have unearthed, my lord, in the course of its investigation. I'll deal with that. What CBI says is very crucial, and I'll, my lord, satisfy our lordships. Now, what is troublesome here is that your lordships have consistently held that if it is, my lord, there are large-scale irregularities, then everybody must go. But if there is possibility of, my lord, looking into and finding out whether who are the tainted people and who are not the tainted people, then, my lord, that, my lord, inquiry must take place. Because your lordships have said that Article 14 clearly commands that those who are innocent cannot be made to suffer because of, my lord, some illegalities on the part of somebody else. My lord, that's the consistent view that your lordships have taken. Now, my lord, what my respectful submission is this, that the advertisement appeared in August of 2016. The first writ petition came to be filed in 2021. Now, my lord, during this large period, long period, my lord, lot went ahead. My lord, advertisement, my lord, was followed by written test, results, my lord, then, my lord, typing and proficiency test, personality test, my lord, all that took place, first counseling, second counseling, third counseling, fourth counseling. Now, my lord, lakhs and lakhs of people had appeared. Lakhs and lakhs of people, almost something like 11 lakh people had appeared. Now, my lord, if for a long time, my lord, all these so-called petitioners who moved the High Court never ever thought fit to go to the High Court. In the course of, my lord, this detailed exercise, after, my lord, the detailed exercise is complete, they move the High Court. Now, this is important. Writ petition 12266 of 2021 was filed because only allegation was that those who have been now sought to be empaneled after expiry of the panel, there was a very limited challenge in that petition. They said, we are on the wait list, panel has expired. Why is it that some people who are now sought to be considered when panel has expired? So, my lord, that was the limited prayer in that writ petition on which this order was made by Justice Gangopadhyay for CBI investigation. There were no allegations of fraud. There was no prayer, my lord, to set aside all, my lord, appointments. Challenge was only for certain persons, perhaps 25 people, who they said are now included in this list, which was wrongly done. Now, my lord, that aspect has not unfortunately engaged attention of the High Court at all. Now, my lord, the other writ which was filed, 12270, which my lord comes, which is arising, which arises into this special petition where I am appearing. There also similar prayer, similar challenge, that these few people have now sought to be empaneled post, my lord, expiry of the. Now, just turn to, my lord, the everments of those two writ petitions, 12266. Just few, my lord, paragraphs. Kindly. Yes. Which page? Page 137. 133. Lord, volume 4 of the convenient compilation, page 1378. 1368, sorry, 1368. One three six eight, my lord. And your lordships will find relevant paragraph at page 1461 first, para 7. Thanks, sir.
Yes.
Para 7, 1461. Your petitioner state that the result was published on 20th December. After declaration of result, petitioners found themselves in the waiting list category, but respondent authorities did not publish any panel as required by the said rules of 2009. Then please kindly omit the page and please see page 1462, para 11. Your petitioners state that because of the assurance given by respondent authorities, petitioners had legitimate expectation that petitioners will be called for counseling, but respondent authorities, although issued notifications for second, third, and fourth phase of counseling, did not call your petitioners for counseling. Now, my lord, omit this. Please kindly turn to para 15. This is their gravamen of the charge, and learned single judge should have confined to this. Your petitioner state, para 15, my lords, that suddenly respondent authorities by memo number so-and-so, dated 2nd September 2019, notified that waiting list panel in relation to Group D has expired. Be it mentioned here that although panel has stated expire on 4th of May, counseling was held even after the said date, and furthermore, panel was published only on June 20, 2019. It's further stated that respondent authorities being statutory authority are under obligation to follow the relevant recruitment rules. Then, my lord, omit all that and please kindly turn to next page. Para 19. Your petitioner state that several candidates have been recommended for appointment to the post of Group D holding rank below than that of petitioners. Furthermore, there are candidates who have been recommended after expiry of panel relating to Group D. And my lord, next page, they give the names of certain persons who were lesser in marks but yet were put ahead. Specific instances. But the grounds are only to that effect in the writ petition. And therefore, Lord, the prayers were, if your lordships will turn to page, Lord, 1471, prayer C, prayer B, sorry, Writ in the nature of mandamus commanding respondent authorities and each of them to fill up remaining 108 vacancies in Group D by appointing your petitioners. A writ in the nature of mandamus commanding respondent authorities and each of them to set aside, resign, withdraw, cancel, quash memo dated 22nd September 2019. Writ in the nature of mandamus commanding respondents and each of them to publish merit list as already appointed in post of Group D disclosing full details including marks obtained. Now, my lord, this was the nature of the writ before the High Court. They wanted to be appointed and they said, look, you are appointing somebody post expiry of the panel. You yourself said panel is expired on 2nd September. How are you considering these people? Fair enough, bro. That was a legitimate case. But that's not something on which learned judge should have issued, my lord, a CBI inquiry. Turn to learned judge's order of, my lord, 5th of February 2024. It is in volume 4, my lord, same volume, page 2825.
5th February.
5th February 2024. No, sorry. No. Just a sec. Give me the, my apologies. Just single judge's order. CBI inquiry.
Just 3.
Yes. Yes, bro. I'm sorry, bro. Page, volume 3, page 289 at 303. Bro, this is 22nd November 2021. As I said, bro, July the writ petition was filed. And bro, on 22nd November 2021, page 303, volume 3, the learned judge, bro, passes this order. No basis at all. Doesn't consider, my lord, what was the nature of case before him. Please see. This matter started snowballing with a writ application filed on 3rd August. Allegation was that petitioners were allowed to participate in selection process, whereas some candidates below them were given appointment, and it is one specific allegation as appears in para 19 that there are candidates who have been recommended after expiry of panel relating to Group D. Then, my lord, West Bengal school certificate, exam board's affidavit is considered. Then, my lord, page 305, second para. Today, what is seen from the affidavit filed by West Bengal Secondary Education Board is surprising. West Bengal Board has stated that board is in possession of original recommendations issued by Commission with District Inspector of Schools memo. Mention upon its recommendation, and entire data was received by them in hard copies and in soft copy of 25 candidates in question, and also other recommendations of Group C and D. Now we are concerned with Group D only. Between the time period of December 2019 to February 20, they have declared that they can produce it if required. Board has said that they also issued approximately 25,000 appointments of teachers, non-teaching staff from 2018. Method has been followed. From this affirmation, came from Commission, be it West Bengal Regional Commission. Accordingly, board issued a question. If Commission or its letter which reached board's office, then how board issued appointment letters? The board has said that they received all recommendation letters, including a pen drive containing such recommendation. Now, my lord, this is on rank jumping. It has nothing to do with those who have been regularly appointed. The affidavit was limited in that regard. They admitted that yes, some 25 people have come who should not have come. Therefore, who prepared and sent recommendation letters to board's office, which are invisible hands who issued recommendation under the signature of chairperson, corrupt of public employment which is required. Where does the learned single judge find the basis for this in the petition? I expressed my view. Investigation by CBI. Today I am learned advocate general said affidavit, no affidavit was called from states, etc. So learned advocate then, my lord, after all that, lord, he says, my lord, Lord, 309, my lord.
Without showing any
Please see, my lord, how learned judge proceeds straight away to pass the order. 308, 308. Yes. 308. Last but second para, my lord. However, after getting the affidavit of board, I find that CBI inquiry is required to identify the miscreants in this matter by whom some letters of recommendations were issued and the board acted on that. Some letters. On the basis of board's affidavit today, I find that commission is not acting in clear hands. I direct Director CBI to constitute committee headed by so-and-so, so-and-so. CBI should also inquire a very important part of this serious illegality and irregularity as to whether there is any money trail in issuance of recommendation letters and subsequent issuance of appointment letters. Preliminary report may file so-and-so. Without showing any disrespect to police force of the state, I am passing this order giving responsibility to CBI only for the reason that both the authorities, commission and board, as also police are controlled by state. This is a matter of education department in a state, and it's such matters instill confidence in public, etc. Now, my lord, with great respect, where was the occasion for learned judge to have done this? We have seen, my lord, what the writ petition was about. What we have been working, my lord, for 4 years to the satisfaction of all concerned. Our families will be ruined, we will be ruined because of this casual inquiry. My lord, with great respect to the learned single judge, this order, my lord, unfortunately is not based on any strong premise. Yes, learned judge may have some views about politics in the state. He is entitled to. He may have personally not seen that there is something wrong. I am not coming in the way of that. But to order a limited inquiry and then take that into a full-scale inquiry by CBI and say that everything is bad, everybody must go out. This is all that was there before the court, my lord. And this can't be the basis for not destroying lives of people.
A call or something else.
Sorry?
We have understood this point.
Yes, sir. Now, my lord, please see what the CBI tells your lordship, High Court. Please turn to affidavit of CBI at page 2825. And this is very crucial, volume 4, 2825. But the High Court has really not understood this, what CBI told the High Court. Yes, my lord.
Yes.
Please see. My lord, para 3 at 2826. During investigation, it was revealed that West Bengal Central Commission had awarded work order to Nyasa Communication Private Limited for scanning and evaluating OMR answer sheets pertaining to selection test of Group D, Group C, Assistant Teacher 9, 10, 11 and 12. Investigation, so my lord, this is important, Nyasa. Investigation established that Puneet Kumar was director and Niladri Das was then vice president of Nyasa during the relevant period. It has been established during investigation Niladri Das was in charge of operations in respect of recruitment examination conducted by West Bengal Board, consequently visited office. Then para 5. Investigation has established that scanning of OMR sheets was undertaken by Nyasa at West Bengal Board office at Acharya Sadan under direct supervision of Niladri Das and in presence of Wbssc officials. It has further been established that Nyasa had further given work order of scanning original OMR to Data Centec Solutions who remained present on the premises of West Bengal Commission for the scanning work. After completing scanning, process data in the form of scanned images on OMR, scanned data were handed over by Data Centec to Nyasa, who took the same to their office located in Noida in digital form, leaving the original hard copies of OMR sheets in the office of West Bengal Commission. West Bengal Commission handed over their answer keys in respect of all subjects to Nyasa for evaluation. That while scanning the original OMR sheets by Data Centec Solutions on behalf of Nyasa, 2 DAT files were generated, etc. Omit all that. Now, my lord, please turn to para 10. This is most crucial, my lord. See, my lord, how casual this investigation is and how High Court has, my lord, made a serious error in relying upon this. Para 10, that during investigation of the case, 3 hard disks were recovered on 15-16 September from residence of Pankaj Bansal, ex-employee of NYASA. Certificate dated 16/9 under 65B of the Evidence Act from Shri Pankaj Bansal was also obtained in triplicate with regard to genuineness of data contained in 3 hard disks. Now see what this error in para 11. During the investigation, data files containing scanned OMRs, DAT files pertaining to aforesaid West Bengal recruitment matters were also seized from Data Centec Solutions, not from Pankaj Bansal. And there is no 65B certificate for that. During investigation, hash value of these data files of Centec were matched with hash value of corresponding files recovered from hard disks seized from Pankaj Bansal and was found to be matching, which establishes that data contained in 3 hard disks recovered from Pankaj Bansal was not contaminated. How can this exercise be done at all? There is no 65B certificate for the OMR sheets which they have allegedly seized, which is the original data. And everybody has proceeded, learned single judge as also the division bench, up all through that yes, OMR sheets have been found and they were tampered with. But the OMR sheets were not legally seized. And that's clearly admitted. Fortunately, the CBI filed an honest affidavit before the High Court. Nobody cared to see it. Now please see para 14 and 15. That during investigation, it emerged that in 2019, Sri Niladri Das had left NYASA and started his own business in the name and style of ND Info Systems, was engaged in business of data processing in line of NYASA. Then 15, that it has emerged from investigation before leaving NYASA, Niladri Das and his staff retained all data pertaining to recruitment. How is it possible, my lord? If a statutory body, my lord, gives this, my lord, contract to party A, his staff leaves and takes away all the files. And CBI files an affidavit. Even after leaving NYASA, Niladri, Pankaj and Hussain kept providing assistance to West Bengal on RTI basis on the data of NYASA, which was manipulated and hosted so and so. Lord, we can't be damned on this evidence. Lord, we have also got right to life, right to livelihood.
Yes, please.
I could understand, my lord, that if now, my lord, just see this one judgment of your lordship's court, one para, and I will leave at that, my lord. Yes, my lord, please turn to, my lord, the judgment. This compilation is at lordship's. My lord, please turn to compilation volume 7. And your lordships may kindly turn to, my lord, page 471 first, para 4 and 11.
Yes.
Page 471. Lord, this is Anamika Mishra, a judgment of Lord, a bench of 3 of your lordship's court, 3 learned judges, my lord. Para 4 may be seen, my lord. We heard the counsel for the parties and are of the view that when no defect was pointed out in regard to written examination and the sole objection was confined to exclusion of group of successful candidates in written examination from interview, there was no justification for cancelling written part of the recruitment examination. On the other hand, situation could have been appropriately met by setting aside recruitment and asking for a fresh interview of all eligible candidates on the basis of written examination and select those who on the basis of written and freshly held interview became eligible for selection. Now, my lord, your lordships therefore struck a balance. Now, this balance has been approved by Justice Chandrachud speaking for this court at page 299. Page 299, and lordships may turn to para 35 first. Lord, this has discussed, Lord, very beautifully the balance between, Lord, the illegalities and, Lord, not doing damage to those who are innocent. Para 35 may first be seen at page 329. In deciding this batch of SLPs, We need not reinvent the wheel. Over the last 5 decades, several decisions of this court have dealt with fundamental issue when the process.
They are aware of the case law, Mr. We need not.
No, my lord, what I am trying to say is this. Just allow me a few lines.
You have also said so.
Yes.
If it's possible to segregate cases, and there is every possibility of segregating cases, that exercise must be done.
That's.
But if it is not possible to segregate cases, then the whole thing will blow up.
I bow down, my lord. But what my respectful submission is this, that no effort has been made here. Court has been carried away. My lord, learned single judge who ordered CBI inquiry had no basis to order such an inquiry, and the division bench has simply been brought overwhelmed by the CBI brought investigation. Now, the criminal case is pending. Supposing brought the criminal case fails tomorrow, Pankaj Bansal is unable to support this. What happens? All of us.
There are two different standards of proof required. The issues are different: civil liability and criminal liability.
No, not on liability, bro. We are all.
Civil issues. That's not the question they're examining. There, they'll be examining on the basis of whether who is guilty, who's not guilty.
No, not that.
Even if the offense is supposed to be committed, who is guilty, who's not guilty. Here, it's not that. That's not the issue.
I agree, my lord.
There's
But
a
my
big difference. Need not go in that aspect.
No. My respectful submission is that we are sought to be thrown out on the basis of that at this stage. That's my submission. Number one sentence, the court says, to treat innocent and the wrongdoers equally by subjecting former to the consequences of cancellation of entire process would be contrary to Article 14 because unequals would then be treated equally. This is what your lordship said, my lord. And paragraphs, my lord, two more paras, 47 and 56, my lord, I commend for your lordship's acceptance. Paragraphs 35, 47, 56 and 64.
Okay.
Now, my lord, this, my lord, one more judgment, my lord, in the
need not go ahead.
No,
that judgment has been referred to.
Just take the citation pages. I'm not going to read, my lord. Inderpreet Gehlon, my lord, at page 357, para 41 and 119. And there again, your lordship said that yes, there are some irregularities, but we are not going to send people home lock, stock, and barrel.
That been read out.
So, my lord, I respectfully submit that therefore, my lord, these petitions deserve to be allowed.
Now, my lord, I appear for two groups of people, my lord. One is teaching staff for class 9 and 10, and one is group D, non-teaching. There are 4 groups, my lord. C, D, 9 and 10, 11 and 12. Total, my lord, of 4 groups who took the exam is 20 lakhs. There were 20 lakhs odd OMR sheets. My lord, all the exams process was between 2016 and 17. I am not giving you the dates. In all cases, my lord, under statutory rules, the waiting panel is for 1 year. The waiting panel, my lord, in all cases expired, my lord, in 2019. We are those, my lord, who were in the main panel, who were selected. We are not a part of the waiting panel. There are 3 allegations, my lord, essentially, in the writ petitions filed in the year 2021, which is 3 years or 2 years down the line after, my lord, our Pakka appointments. And I say, my lord, and I have seen, in none of the writ petitions, the way showed you one. In none of the writ petitions, my lord, is there a prayer that you strike down and remove those who have since been appointed in government service. The respondents, my lord, do not include those who have been appointed even under a representative capacity under Order 1 Rule 8. Those were the nature of prayers. Basically, prayer was, you give us an appointment in the year 2021. So there are 3 types of allegations, my lord, apart from this prayer business. One, that people, my lord, have been appointed from the waiting panel after the waiting panel expired. One allegation. We don't represent those people. Second allegation of Milord rank jumping. Somebody is at number 10,000, he is brought in at 5,000. And the third allegation is this tampering of OMR sheets. Now, Milord, please note, the OMR sheets, Milord, which are physical, like an exam answer sheet, the rules require their destruction after 1 year. So all the 20 lakh sheets have since been destroyed. The OMR sheets, Milord, as sheets go, was never uploaded anywhere. What was uploaded, Milord, was only the result. Now, Milord, I want to tell you what the process was. Kindly note that. The commission, Milord, is authorized to conduct exams and appoint people. The commission outsources, Milord, to a company called NISA. It outsources the job of scanning the 20 lakh OMR physical sheets into an electronic form, like an electronic photocopy, Milord, if I may use the phrase. And then NISA, Milord, has to evaluate, and the evaluation is through a computer. It's not physical evaluation, that one answer is correct, one answer is wrong. It's an evaluation because it's 20 lakhs. Evaluate, Milord, the OMR sheets according to the key answers. Give, Milord, the final result thereof of the analysis to, Milord, the commission, and the commission, like a post office, will publish the result. This is how, Milord, it was given to NISA. What NISA did was, Milord, the job of scanning, the mechanical job, was, Milord, assigned, or you can say sublet, to a company called Data Scan, Milord. Data Scan Tech. I'm using Data Scan. So, Milord, what happened was, the actual physical OMR sheets were electronically scanned, Milord, like a photocopy, by, Milord, the agent called Data Scan Tech on computer. After scanning, Milord, they gave it to, Milord, NISA. NISA evaluated and gave the list of successful, etc., to the commission. So now what is most important, Milord, it is critical, apart from other things. The basic original hard disk, which will contain the scanned, original scanned, first scan copy, like a first photocopy, is the hard disk of the computer in which the scanning was done by Data Scan. That, Milord, is equal to the original OMR sheet. Because the starting point, Milord, is the original. Original has since been destroyed 5 years ago. This is the closest to the original because it was scanned, Milord, in the first instance. Kindly note that. So the original scanning is the scanning, Milord, of the original sheets. Now please note, Milord, and I have gone through all the reports. The original hard disk of the computer which did the scanning is missing. It is not to be found. There is no reference to it. It is not there. So, Milord, any comparison with either Bansal or Niladri Das, to which I will come, that comparison is meaningless if you don't have either the original or the scanned original. So if you don't have a reference point, there is no gain saying that some photocopy of somebody matches with somebody. That's very, very important. So the original hard disk ballot is not to be found, number one. Number two, the Supreme Court was aware that ballot 3 hard disks have been found with Bansal in Noida. And found ballot, your lordship may note, in the year 2022, much after NISA was gone, much after the results, much after appointment. They were found with an employee called Bansal, or he's an ex-employee. 3 hard disks were found. Now please note below something very important. The factum of finding these 3 hard disks with Bansal in 22 was known to the Supreme Court when the Supreme Court below ordered a remand. The date of the Supreme Court's remand is 9/11/23 to the division bench.
Which page?
Yeah, I'll give you the page note. Page is 734 of the convenience compilation, which I will now just show for a second, but just note this one. Volume 3, CC volume 3, page 734. Now, the Supreme Court was aware of the finding, my lord, with Bansal of the 3 hard disks. So the Supreme Court took pains, my lord, in that order. Kindly note, my lord, paras 6 to 9. The Supreme Court in a nutshell said that the issue of admissibility of what was procured from Bansal is extremely critical, and the division bench will not be look into it. This is 6 to 9. I'll read it, my lord, in a second. Now, when the matter goes back, I'll just complete the sequence. When the matter goes back to the High Court, my lord, after the remand, the Additional Solicitor General produced, my lord, in a sealed cover, the 3 hard disks seized from Bansal, saying that they were sent to CFSL Hyderabad. Hyderabad returned it for whatever reason. Kindly just note that. They were sent to CFSL Hyderabad by CBI. They were returned by Hyderabad. They were produced in the High Court, and the Solicitor General said that since Hyderabad has not returned, we will send it to CFSL Kolkata. They were sent to CFSL Kolkata. But, my lord, that report has not come. And the division bench, my lord, has given judgment without awaiting that report, which according to them is crucial. According to me, it is not that important because the original, my lord, is still missing. Now, my lord, 6 to 9, your lordship may note. At 734, kindly turn, my lord, to 737. And according to me, my lord, the division bench order suffers from a fatal flaw of not following the remand of this court on an issue which is critical. Kindly turn to, my lord, 737. Your lordship have that. Civil appeal number so-and-so relates to termination of 842 of Group C, mainly based on the mismatch of data comparing the mirror image of OMR, which they claim to have recovered. This is recovery from Bansal. Authenticity of this material is yet to be established. SLP so-and-so involves termination of Group D, again on the basis of mismatch revealed from the content of the images, again from Bansal. SLP arises out of proceeding initiated by 9 and 10, mainly to preclude these OMR from being considered. So-and-so single judge posted the directed posting of OMR sheets, etc., etc. Matter came to. Now 7. We have heard submissions, etc. for so-and-so. We are of the view. Substantive hearing of all proceedings which generate the set of appeal ought to be conducted by High Court. We are apprised all writ petitions, etc. So, my lord, it goes back. Then, my lord, your lordship will find, my lord, para 9. The question, or my lord, just one line above that. In none of the orders above para 9, impugned before us, there is no clear-cut finding that there is distortion. This is very, very important. No clear-cut finding of distortion. My lords, get that line just above para 9. So this has to be found, namely the distortion. That is the manipulation. For one of the three challenges, as I've said, Milord. Not rank jumping, not, Milord, outside the waiting period, but this. Milord, sorry, 2 lines above the para 9, very important. The argument of corrupting the original sheets is yet to be supported by cogent evidence. In none of the orders impugned, there is any clear-cut finding. The question of exercise of powers also arises out of discovery of electronically stored votes. Serious allegations of manipulation, record exchange of money, allegations have to be established through evidence. It is in our opinion, considering the importance of the matter, number of persons affected, etc., matter goes to the DP. Now, we will see what transpired in the High Court when the Solicitor General made that submission. The order, Milord, of the division bench, please note, is dated 5/2/24. And that order, Milord, is to be found in volume 3, page 958, in the same volume, at, Milord, 1014. I'll just read that one line. 1014, fourth line from top. 1014, fourth line. He submits that the ASG, that the original electronic device, that is not seized from Bansal, was sent to CFSL, Hyderabad, who returned the same. The original appearance is CBI, in fact, brought to court. He submits that CBI intends to place these devices with CFSL Kolkata for necessary processing. The High Court returned the device to him that you send it there. This, Milord, went, Milord, to Calcutta, but has not seen the light of the day. So, Milord, the remand by the Supreme Court on something which is seriously contested, something which is the base of the matter, is sent, Milord, to CFSL on 5/2/24. It is recorded and judgment is given. And that, Milord, you'll also find 1016 bottom. 1016 bottom.
We are aware of all this.
Yes. So, Milord, this is how it is said. This is how, Milord, it has gone. Now something very, very important, Milord. So the whole focus was on the 3 hard disks, Milord, which were seized from Bansal. I submit, Milord, Bansal had no right to have them. God knows how they were with Bansal, in what capacity, Milord, they were there. Whether they were tampered at Bansal's end, we don't know. All this time has elapsed. And Bansal's certificate of 65B, Milord, according to me, is bunkum. But something very, very important now. In the latest, Milord, report by the CBI, it is, Milord, a third supplementary charge sheet. Please note that and I'll read that. In the third supplementary charge sheet, Milord, now new material comes. That is supposedly, Milord, a hard disk, Milord, from a man called Niladri Das. Niladri Das, Milord, is the current employer of Bansal. He is employee of Bansal or employer of Bansal. That's the connection. The name is Niladri Das. Now, Niladri Das, Milord, also has a hard disk. Apparently of the same exam. I don't know how, where. And this is, Milord, their investigation. Now, it's very important to note, this is investigation, Milord. This is not final proof. This is not evidence, it's investigation. But for whatever it is, have a look, Milord, at that report. This, Milord, report is, Milord, is called IA 4242 of 2025 in SLP 9637 called Gopinath Bhanja. That is not, Milord, in the...
67.
Is not in the convenience, Milord, because it has now come. It is, Milord, IA 4242/25 in SLP...
4242.
4242 by 25 in SLP number 9637 by 24. The name of the case is Gopinath Bhanja.
Yes.
Now, Milord, in this you also will find. Anyway, Milord, it's a part what CBI has given. The CBI has not given to, it's a part of the charge sheet. One.
9637 is the IA number.
Now just see this, Milord. Your Lordship, if your Lordship will have this, this is how it is filed.
This is
It is SLP, my Lord, 9637.
number is 4242.
IA 4242 by 25, my Lord.
Okay.
It is a thick volume.
Why do you want to show us this? Why do you want to show us this?
To show you, my Lord, that all is not ending with the sacrosanct, my Lord, hard disk of Bansal. There is some Niladri Das whose hard disk now says only 152 are tempered as opposed to 4,000 tempered in the High Court, 952 tempered before the Supreme Court, now only 152. What is going on? This is what I want.
How can you say from the hard disk how many tempered? How can you say from that?
My Lord, CBI is saying, I am reading from CBI. I want to show from CBI, not my statement, my Lord. Just turn to 163 of this compilation. Yes, this is the one.
Can you give us a copy? We don't have a copy.
Well, I have to take it from CBI. CBI के पास है, मेरे पास थोड़ी है. छोड़ो ना यार. Kindly, my Lord, have a look at 163.
Yes.
The Lordship will find. 1 minute, please. Kindly see at 163 bottom. Para 59.
Para 59. No, it's not there at 163.
163, my Lord.
74.
My Lord, on the top it is 163, handwritten page is 153.
What is the date of this supplementary charge sheet?
8th January.
On
24.
top it is
163.
My Lord, the printed page right on the top is 163. A handwritten page encircled is 153.
No. Next one.
My Lord, if Lordship may have, Mr. Court Master, kindly see this one.
Yes, now
IA volume 1.
Yes, yes, yes.
Lord, para 59 at the bottom of the page.
Yes.
Conspiracy of Niladri Das and Naisa during investigation prior to recovery of disk from Bansal. So something before, which has not surfaced till now. Niladri Das also submitted one hard disk providing data relating to so-and-so pertaining to teachers, that is 9 and 10. Scrutiny of the data of hard disk produced by Niladri reveals an OMR sheet, including OMR of 152, whose OMRs are found to be manipulated. In his statement, Bansal has stated he was asked by Niladri Das to prepare one hard disk for submission to CBI. So much for this, my Lord Bansal. To submit one hard disk for Bansal. Niladri directed Bansal not to keep the sheets pertaining to those candidates whose OMRs were manipulated. Due to negligence of Bansal, OMRs of 150T could not be removed from the hard disk which was provided to CBI. This proves a conspiracy. Now look at this. Now Bansal says, according to Niladri Das, Bansal prepared his own hard disk to be given to CBI. So he's giving something to CBI. He's got something in his pocket, something Niladri Das has got. So, my Lord, what is the proof of this investigation? What is the worth of this investigation? And therefore, the affidavit, my Lord, of CBI, on which the High Court placed reliance, cannot be, my Lord, looked at all. This is the state of evidence on which, my Lord, thousands of people serving for the last 10 years are to be ousted.
Now, what is stated is something different.
Lordship is
what is stated over here is that Bansal had asked him to remove all this, but he says
that's the subsequent part. But see the third line. In his statement, Bansal stated he was asked by Niladri to prepare one hard disk for CBI.
Correct.
What does that mean, my Lord? That one guy is Panchab is saying, I asked.
No. What he wanted to prepare a hard disk, removing all those.
Correct. All I'm saying is this material on which you check out people? Why did the High Court not wait for CFSL Kolkata?
We take it overall material, not one particular evidence.
My Lord, what is overall material is only Bansal. There is no other material.
Overall material is OMR sheets have vanished.
Not vanished, my lord. They are destroyed after 1 year under the rules. We can't help it. My lord, rules say,
Now,
can
the
anybody
scanned copies are revealing so many other things.
original scan is not available.
Original-
Original scan in the hard disk of
All the more reasons we have when there's so many irregularities.
But my lord,
that
what
come
can I
out.
do? They are not in my control. Nobody is alleging.
I know, we are not, look, please. Question is not that. There are two questions. There are some people who have been found to have manipulated. Their results are manipulated where there's.
Sir, I am respectfully submitting. This finding of manipulation is not conclusive. It cannot be based on conclusions of this nature.
Okay.
And then to do away with services of thousands of people with families after a lapse of below 5 years or 7 years, at the instance of a writ petitioner who took the exam, who lost in the exam, and then filed a writ after 5 years. My lord, there is a rule of estoppel. This court has created any number of judgments. You take an exam, you fail, you wait for 5 years, fellows are getting, my lord, jobs, and those jobs are now to be ousted. That, my lord, is my submission.
May I take 2 minutes?
I'll just take 10 minutes.
I just.
Also, I'm appearing in 3 of these cases, less than 10 minutes actually.
And Mr. Simple.
So, Shadan.
You want to come?
I'm appearing for the
So, my lord,
non-tainted category, my lord.
Well, I'm also for non-tainted. I'll go after.
I appear for 3 in 3 petitions, my lord, all untainted. The difference is that in one, they had been selected earlier in an earlier selection, and therefore they were already in service when this exam took place. However, they took this exam because they wanted a district closer to their home. So that is why, because some of them got districts closer to their home and through this selection, therefore they got selected. I am appearing, my lord, in 34.11.
Give your judges, otherwise we won't be able to write it down like that.
34.11.
Put it on a piece of paper, we won't be able to.
Yes, my lord.
There's
We
so
have
many
a,
of you over here.
we have a piece of paper. I'll just give it to you. 34.11, 34.12.
What's your argument, Mr. Prashant?
Yes, my lord. The argument is simple, that the High Court has quashed all the selections. In this case, even assuming that this Bansal's hard disk is a correct copy of what was there originally, that CBI itself has separated those whose marks were manipulated and those whose marks were not manipulated. If your lordship sees, and it is on the basis of that very hard disk found with Bansal. If your lordship sees the CBI's written submissions, which are in volume 6, I believe, there in para 5, 6, page number 25 of volume 6. And in that, my lord, paras 5, they say about the recovery of this disk from Bansal. Then they say that the investigation of these hard disks in the aforesaid 4 cases of CBI has revealed that numerous candidates were declared successful and were placed in the panel waitlist who had submitted blank OMR sheets. This is one. Marks of written examinations, typing test, personality test, etc. were manipulated for various candidates in order to declare such candidates as successful candidates. This is 2. Accused officials of Wbssc together with the accused officials of NCPL manipulated marks of the candidates to whom undue favor was bestowed. This is the reason why. The marks awarded and declared by Wbssc were different from the actual marks secured by undeserving candidates available in the 3 hard disks recovered from Pankaj Bansal. The following are the figures pertaining to manipulation of OMR sheets in all the 4. So this is after the complete investigation. They have said that total instances of manipulation, they say, in each of these cases finally totals to 3481. In these 3 cases put together totals to 3481, or maybe a lot more. But in any case, these are the total instances of manipulation. These are the total instances of number of candidates who submitted blank OMR sheets. Then they say during course of the investigation, the 3 hard disks from Bansal, certificate under the Evidence Act was obtained from him. It was also revealed during investigation that during his working tenure, Bansal used to officially deal with such hard disks which he had retained before leaving the company, etc. Then they say the investigation has revealed that appointment of ineligible candidates was done by collecting bribes through an organized racket of agents. That's again the motive, etc. These bribe amounts were shared between agents, officials, and minister. The lists of ineligible candidates were finalized in the residential office of Partha Banerjee, which was then handed over to the concerned officials of Wbssc. The accused officials thereafter, in furtherance of the criminal conspiracy, manipulated the marks of the candidates to declare them eligible for recruitment. Further, the accused officials illegally appointed ineligible candidates against vacancies which were supposed to be used on the subsequent recruit. So some people were appointed in excess of the number of vacancies, etc. Further, in order to remove evidences and any wrongdoing and avoid detection, original OMRs and digital data were destroyed by the accused officials. Pausing here, my lord. Assuming that of course, the original was destroyed, etc. But the whole irregularities and the manipulation have been discovered on the basis of these seized hard disks which supposedly contain a correct copy from Bansal. Now, assuming that to be correct, if we assume that to be correct, that tells you whose marks were manipulated, whose marks were not manipulated. It tells you who had left blank OMR sheets, who had not left blank OMR sheets. It tells you who were appointed in excess of the vacancies, who were not appointed in excess of the vacancies. Now, Lord, we in all these 3 cases in which I am appearing, I am appearing for candidates against whom nothing wrong was found. No manipulation of marks, no blank OMR sheets, not appointed in excess of the vacancies, etc. So on what basis, my lord, do our selections get set aside? Because even assuming that this Bansal's hard disk is the gospel truth, even then, my lord, on that basis, it shows that we are totally untainted, we are totally blameless. So therefore, my lord, and that's what your lordships have held in so many judgments. In Kahlon, in Rakesh, PU, I have, my lord, prepared a short written note on these judgments.
Okay.
Just hand over this.
So that law is well settled.
Yes,
Does
that
not
law
require detailed.
Yes. Your lordship has settled that law. So therefore, in this.
We have understood your argument that it's possible to segregate the ones who are tainted from from those who are untainted. So why not apply that?
Yes, and the second argument is, this is the second argument, we were not given any notice by the High Court. Throughout, my lord, neither a public notice nor any other notice was issued.
Everybody was aware of the proceedings. If you're not aware, then there's something
wrong. But, my lord, we don't. Yes, we didn't think that
I want to say something, my lord, if lordship permits me.
You can't cancel.
Lordship may permit me for 2 minutes.
And, my lord, some of us.
Ranjit Kumar, you had already argued, I thought.
No, I know, my lord, I argued, my lord, but I did not have, your lordship don't have my SLP numbers. So I just want to, because I am in the same category what Mr. Prashant Bhushan has argued, that I was working, one of us has to retire this year in May.
No,
okay. If your lordship could kindly, if your lordship don't mind, either note my SLP numbers, my lord.
You give it in writing.
Sorry, my lord.
Just give it in writing.
Lordship, I'll give it in writing, my lord, and I have prepared a small note of 2 pages, my lord, if I may be permitted. I'm sorry, I'm not there.
That we are not permitting. That we are not permitting, otherwise we'll take.
So, my lord, had we known that the entire selections are going to be cancelled, then we would have, some of us would have probably applied to the court.
So that's too late in the day.
No such intimation was given to anybody. And secondly, my lord, some of us had selected the earlier selection.
Your lordship has heard this.
Great hardship. Great hardship.
May I, Mr. Sibbal is next. Mr. Sibbal is next.
Let
I'm
Mr.
just going to
Sipal
take
connect.
2 minutes. Your lordships have heard it, Malads. The issue is very simple. If you want to manipulate the OMR sheet, it has to be scanned first. The original sheet can't be manipulated. It has to be scanned. Whatever scanning was available, the CBI has detected where there's manipulation, where there is no manipulation. The CBI itself has found that, Malads. And the fate of 775 candidates is at stake. So if there's a blank sheet, Malads, the CBI has investigated. If it's rank jumping, the CBI is investigated. If beyond the expiry of the panel, people have appointed, CBI is investigated. Now, Malads, in the so-called Bansal scanned copy, Malads, there are names of people whose OMR sheets are not manipulated, that the CBI has found. If the CBI has found that, Malads, there's no occasion for the High Court to say that I'd set aside that appointment also. There's no evidence at all. You have to set aside an appointment on the basis of some assumption. And if the records are not available, the original OMR is not available, how do you assume that since others are manipulated, this also must have been manipulated? At least the investigating agency has not come to that conclusion. So therefore, my respectful submission is, also have heard all this time and again, Malads, that at this point in time, there is no method for finding out that those whose OMR sheets are not manipulated should also, their appointments should be set aside. That's just unacceptable in law, Malads. That's all that.
I'm just making one submission.
One by one now.
Plus, the submission is, plus that segregation is eminently possible in this case. I am for C and D group, totally untainted. No AMR, none of the others, no problem with us at all. I'm in that group, totally clean. As of today, there is not even an allegation against any of my clients which I'm representing. Plus, why is it possible? Firstly, plus the High Court gave an opportunity to, the OMRs were uploaded. The High Court gave an opportunity to us to examine them. Some of us examined it, we found it identical. Not a single person objected to it in the High Court. It's noted in para 289 of the impugned order. I'll just read it. The 3 hard disks seized by CBI had been produced in court. CBI had granted inspection of documents downloaded from such hard disks to persons seeking such inspection pursuant to orders of this bench. None of the persons taking inspections have contended that the OMA sheets are not theirs. So, Mullah, the opportunity was given, it was examined, we are confirming it was ours. So today, if anybody is saying it's not ours, it's an afterthought before the Supreme Court, number one. Plus, number two, there is hashtags have matched from data Scantech and Mullah, what was found with Pankaj Bansal. The argument there is that the file name has, the extension has changed, it's .dat. That was the argument that was made. Plus, my respectful submission is hashtag will match if the content of the file is same. If you change the file name, no difficulty, hashtag will still be the same. If you change the extension, if you make a Word file, a doc file, a PDF file, it will still be the same. But even if you press a space bar in actual file, in the open file, then the hashtags change. So .dat is irrelevant, the hashtags do match. And I don't want to be crushed with the others because there is some irregularity on their part. Plus, finally, is it identifiable today or not? I have made a one-pager. Those numbers of individuals and names are before your lordships, against which there is allegation either by the commission or by the CBI. Those are very much there. So your lordships are in a position at a granular level to identify the individuals against whom there is allegation and against whom there is no allegation. And we, as of today, there's not even an allegation by anybody. We are willing to give an undertaking that in the event something credible were to or at all were to arise by any investigative agency or agency of the state, please knock us out. But please don't bury us with the others because there's not even an allegation today. Plus that chart of one page is there. It clearly, I've given the page numbers. Group C, Group D. I've given the page numbers. If your lordships will go to these page numbers, the list of candidates is there. So granular level data is available before your lordships today to do the segregation. Only to that extent, I respectfully submit the High Court judgment is wrong. I'm grateful.
My lords, I also represent untainted teachers, my lords. My lords, just continuing this line. Yes, my lords, continuing this line. I represent untainted teachers, my lords. So class 9, 10, 11 and 12. We are not outside the panel. There is no irregularity. We have been teaching for 6 years already, my lords. So that is the first thing, my lords. And I am in SLP Civil 9586. I will hand over, my lords, just a few numbers for my lords' consideration, just to make it convenient. Now, my lords, just three very brief points because your lordships have been hearing this for many days running. One, my lords, the CBI's own submissions, which are before my lords, in fact, gives you the numbers of three categories of those who are tainted. One, and this is in the note, my lords. So your lordships don't have to be inconvenienced, my lords. This is in my note, page 4. Page 4, ma'am. It's a very brief note, my lords. It just extracts data from the CBI's own.
It's not going to be possible to take notes like this.
Very well, my lords. This is also filed, my lords.
We are noting down whatever is there.
Yes.
But other than that,
It's volume 6, my lords. It's also been filed. It's been filed by the CBI. This note is also filed. I just thought for my lord's convenience. And the point here is very simply this, my lords. Volume 6. The CBI says, now please see, my lords, when it comes to assistant teachers, which is the candidates who are untainted, who I represent.
Which paragraph are you referring to?
My lords, this is paragraph 8, my lords, page 4. Paragraph 8 in my note, page 4. This is taken from the CBI submissions. I have only reproduced it. Now, 3 lakh candidates take the exam for teachers, assistant teachers, my lords. 3 lakh candidates. 20 lakh is group C and D. 3 lakh is this. Now, please see the irregularities or the tainting. And I want to show my lords this numbers because please see the minuscule minority, which is this number. Assistant teacher, my lords, have this. Appointments after expiry, 183. Classes 9 and 10. And classes 11 and 12, my lords, have this, 39. Candidates beyond the panel or waitlist, 110 and 18. Now, please see the total instances of manipulation. This is on 3 lakh candidates. Please see, my lords. Assistant teachers, this is line 2, 952, 9 and 10. And 11 and 12 is 907. And the ones who submit blank OMAs is 22 and 15. So in each category, my lords, this is 8% and 10% of the total number of candidates who take these exams. Now, your lordships in Vanshika, now, my lords, I've just extracted a case which is part of the compilation for my lord's convenience. The High Court refuses to accept your lordship's jurisprudence in Vanshika Yadav, my lords. And Vanshika Yadav, page 5, is extremely important because my lords took the trouble of making 2 points in Vanshika. That at the first level, my lords has this para 10 of the note, my lords. This is the last page. And this is in volume 7 of a compilation of judgments which my lords have. I've just extracted.
Yes.
Your lordships do 2 things in Vanshika. One, you take the trouble of segregating the tainted from the untainted.
Yes.
And please note that tainted vis-a-vis the teachers is a minuscule minority. I've shown that from the CBI's numbers, my lords.
Yes.
Then your lordships make a second point in Vanshika Yadav, that even when the CBI investigation is underway, solely because there are irregularities of a nature, you cannot stop the process of segregation and terminate everyone. Your lordships have been confronted with cases similar to this because over in this country, recruitment to government jobs, teaching positions, overwhelming numbers of candidates apply. Lakhs and lakhs apply for jobs in the police, jobs in teaching, jobs as engineers, and therefore there tends to be some manipulation across the board. But when the manipulation is of a nature of twofold, minuscule minority as well as the ability to segregate the tainted from the untainted, which our investigating agency is doing, then your lordships responded with Vanshika by saying the response has to be proportionate. That is the language your lordships use, that the response to a situation like this must be proportionate. The High Court, by refusing to segregate and by terminating en masse, even untainted like ourselves, who have not been heard, my lords. This is the other part of the story. We were never given notice. We were not heard. We have been teaching faithfully with due diligence over the last 6 years. There is not a blemish in how we've taken the exam or how we have cleared the exam. The High Court refuses to reflect on the jurisprudence laid down by my lords in Vanshika. And that is the element that I have compiled here on this page, my lords, for my lords' convenience. And my lords, very importantly, my lords, your lordships were troubled by the destruction of the OMRs. So I'd like to deal with that very briefly and head on. It's on the same page. That this is paragraph 12, my lords. And I'll end with this because this has troubled my lord, the Chief Justice. My lords, Rule 21, please see paragraph 12, I've extracted the rule. Rule 21 of the West Bengal Central School Service Commission, selection for appointment. And this is part of the volume of rules and statutes, which is part of my lordship's compilations. Service Commission, selection for appointment to the post of teachers for classes 9 and 10 and 11 and 12. These rules are specific per class. Very categorically say this, and I've extracted this. The written answer scripts, OMRs of examinations, shall be destroyed by the Commission after 1 year from the date of publication of the panel. It is now, at the time the High Court is seized, it is many years after the publication of the panel. In fact, I think it's 6 years after the publication of the panel. So there was not a concerted conspiracy. The rules and this rule in specific has been followed. For this, untainted candidates like myself, my lords, should not suffer. The investigation by the CBI, 3 supplementary charge sheets later, their submissions which they filed before my lords, all indicate that one, they have been able to segregate the tainted from the untainted. And if anything remains in terms of filing of the charge sheets, that is a process of enforcement of criminal justice, and that will happen. But for that, a disproportionate response is what the learned High Court does, my lords, which is en masse termination. That violates.
Next.
I beg to appear. Item number 30.
May I?
Item number 33, I'll just take 2 minutes of your lordship's time. Lord, would your lordship turn to paragraph 240 of the impugned order? Lord, there is a table there at paragraph 240 of the impugned order.
Yes.
Lord, that paragraph gives the percentages of irregularity. It ranges from 8.5, goes up to 44.87. Lord, I am appearing for untainted candidates in Group C and Group D.
Yes.
Lord, the maximum is 44.87. Paragraph 242, the High Court says, Lord, there might be further possibility of further candidates, numbers increasing, but that has not happened. So the maximum your lordship would have is 44.87%. Lord, I am now citing Jeremy Bentham, Lord, the greatest good of the greatest number is the object of law. Lord, here, you're being invited to cull the entire number of sheep, cull them, just because there are a minority of wolves. Lord, when it doesn't exceed 50%, Lord, this culling cannot be done. Please don't throw the baby with the bathwater. Lord, if your lordship then turns to paragraph 243 at the bottom of the page, last sentence. Bona fide candidates who had participated in the selection process deserved a lot better and far more humane treatment. Lord, this is what I would invite my lords to do. Untainted candidates deserve a far more humane treatment than mass culling. I'm obliged.
Milord, my case is a little unique, Milord. Lordship may kindly take up SLP number 16249. And I'll be, Milord, very, very brief. I'll just show 2 pages, Milord. 16249, Milord. 16249.
Yes, please.
Now, Milord, your Lordship can take it from me that I am one of the 33 candidates against whom no wrongdoing was established. That is, Milord, at page 460, read with 464 of my brief. I'm not troubling my lords, Milord. I am one of the candidates against whom no wrongdoing has been established so far, number 1. Number 2, Milord, when the matter was before my lords, by the order of 9th of November 23, your lordships were pleased to remand back, Milord, 19 petitions to the Calcutta High Court. My matter, Milord, was not one of the 19. My matter was not, Milord, remanded back to the High Court. So I was not heard before your lordships, Milord, in this court. Number 3, Milord, the High Court on remand, Milord, directed notices to be issued. Notice was issued to me, Milord, in December 2023. Very next month, Milord, in January 24, Milord, I approached the Calcutta High Court and filed an impleadment. Now, Milord, kindly see the impugned judgment. I will just show 2 pages and I'm done, Milord. Page 157, Milord. Page 157. And para 124, Milord.
Yes.
In our understanding, all writ petitions relating to the recruitment process initiated in the year 2016 have not been directed to be heard by the division bench, but only those writ petitions relating to the categories as noted above in respect of the 2016 recruitment process and instituted in 21-22. Milord, this is very important. I'm so sorry, Milord. Page 157, para 124. I'm so sorry, Milord. 157 in my brief, Milord, para 124.
You are referring to the internal page.
Milord,
Running page.
Milord, it's a common one volume itself. I'm so sorry, Milord.
I see you're referring to the internal page. Here there are 2 pages.
Paragraph number? Maybe I'm looking at a different file. I'm looking at the first file. I'm looking at 33.
Let's see, read from my.
Yes.
Yes.
Lordship has it, Milord?
Yes.
I'll just read it again, Milord, quickly. Page 157, para 124.
Yes.
In our understanding, all writ petitions relating to the recruitment process initiated in the year 2016 have not been directed to be heard by the division bench, but only those writ petitions relating to the categories as noted above in respect of the 2016 recruitment process and instituted, Lordship may mark, instituted in 2021-22 and the appeals arising out of the orders passed in such writ petitions. Then, Milord, para 125. Consequently, we have the jurisdiction to hear and dispose of appeals arising out of the orders passed in the 4 categories of matters in writ petitions filed in 2021-22, contours of our jurisdiction to decide the writ petitions and appeals emanating out of orders passed in such writ petitions having been adverted to, we shall proceed to decide such matters which fall within our parameters. So what was heard, what was remanded by the Supreme Court was not, Milord, my matter. What was heard by the High Court, Milord, is not my matter because my writ petition was instituted in 2023 and not 21-22. And now your Lordship may kindly come to page 279. 279. 279, right in the beginning, Milord, and the first very line of the page. Lordship may kindly mark WPA 3846 of 2023. The para starts, Milord, from Milord, page 275 conclusion, para Milord 364, 365.
Para 279?
Milord, page 269. Page
para number.
This is Milord 365, 366 in fact, 366. Para 366 at 279, just Lordship may mark WPA 3846, which is my writ petition. WPA 3846 of 2023,
And my lord, at para 280, the last line, after my lord, all the narrations of these WPAs are over.
Which paragraph are you referring to?
I'm so sorry, my lord, page 279. I'm so sorry.
First line.
Very first line, my
Very
lord, of
first line.
page 279.
Oh, list of cases.
Para 366, page
Yes.
279, the first, my lord, the second, my lord, WPA 3846.
3846.
Yes.
Your Lordship has it, my lord, 3846 of 2023, and at the next page, after the narration of all these listing, along with all connected applications are released from the list. So my matter, my lord, was specifically released from the list. Then, my lord, the next paragraph, 367. So far as the appeals are concerned, all appeals emanating out of orders passed by the learned single judge in writ petitions filed into 2021.
Just 1 minute.
I'm so sorry.
It's released or is released. Huh? It is not covered by this.
Then you may not be covered by the judgment.
That's right. That is my only point. My lord, my matter was released. My matter was not before the Supreme Court.
Then why are you here?
Because I am affected, my lord, by the direction of page 272, I've been thrown out. When my matter is pending before the High Court. You know, this is really disturbing. Page 272, Roman 2. All appointments granted in the selection process involved being violative of 14 and 16 are declared null and void. My matter is still pending, my lord, before the High Court. I have not been heard.
No, your matter will be heard.
Yes, well, that clarification is all that
We
I'm
have-
asking.
1 minute, please. We have to read 1 and 2 together.
Yes.
Read 1.
Writ petitions appearing in the monthly list of March 24 of this bench, which are not filed and numbered in the years 21-22, are released from the list due to lack of jurisdiction determination. I do not fall, my lord. All I want is a clarification that, my lord, I cannot be, my lord, the effect of this order cannot, my lord, I can't be affected by this order.
Petition monthly list of this bench, which are not filed and numbered in the years will be released from, no, this is also released.
This 23 and 24.
No, this will apply to the writ petitions which are disposed of and not.
Therefore, all that I'm saying is that I cannot be terminated on the basis of this order. That's all that I'm saying. That clarification is all that I'm wanting, my lord. Nothing more. I'm not entering into this dispute at all.
Who's the parent, state of West Bengal, please, on this point, just inform us. No, later on in your turn.
That's all, my lord.
The High Court website shows your matter is pending.
My lord, I'm so sorry.
The High Court website must be showing your matter is still pending.
It's still pending, yes. Yes, yes. But that clarification, I cannot be dismissed, my lord, on the basis of this direction or not.
How can it be?
My lord, the state has to clarify.
State has to clarify, move an application for clarification to the court. You get that?
My lord,
Instead of running over here, you should have moved an application asking clarification with regard to paragraph number 2. With reference to the paragraph, it says such and such are released from this list.
My lord, I am told that they will not entertain any such applications. All, my lord, result of this impugned judgment is all, my lord, appointed.
Okay, fine. Next case. Next.
Group, I appear for group.
May I, my lords, may I mention, may I present, my lords, if I may, just one at a time, my lords. My lords, I am limiting myself.
I just want
My
to
lords.
mention 2 facts and get it.
I'll only take 2 minutes.
How
of my
can we
lords.
permit this? We cannot have this.
I beg your
My
I
lords,
beg to appear in group
may I?
C groups.
No, please, no.
In SLP 10617.
You have also argued.
My lord, 1 point.
No, I have not argued, my lords. I have not
You are
present.
there.
I was not there, my lords. I am appearing for the first time before, my lord.
Okay, please.
So may I only take 5 minutes of my lord's time to
Yes,
submit on something which has not been addressed before this honorable court? I will not repeat anything, my lords. I'm limiting my submissions to the aspect of electronic evidence. I am in 34.63 for Group D,
What do you say on
tainted, my lords.
What do you say on electronic evidence?
My lords, repeatedly, the issues with respect to the hard disks have been mentioned and about this provision of a 65B certificate or not. But the crux of the issue really goes beyond that to the provenance, and that decides every aspect in terms of the acceptance or otherwise of the evidence, my lords. And this is based on 2 judgments that have come from this honorable court and
We are not,
reiterated
look,
the third
please,
judgment.
let's be very
I
clear.
am not going
Just
to
1 minute, please. We are not concerned over here with the evidence, sir.
Yes, ma'am.
Neither are we concerned with Anwar versus Bashir or Navjot Sandhu.
Yes. I am not going into Anwar versus Bashir or Arjun Pandit Rao to argue about the sustainability or otherwise of the electronic evidence, my lord. I am only limiting my submission to whether the so-called category of tainted can even be mentioned as such based on the evidence that the CBI is relying on today at this juncture. And I'm relying on the Mohammed Arif case of this honorable court, which talks about the first level that has to be crossed by the prosecution will have to be whether that is not prosecution, my lord, my apologies, for the state would be whether this is even sustainable for removing these persons from their appointments or not. The first foremost, my lords, is that these are petitioners who have not been given inspection. They have been unilaterally categorized as tainted on the basis of the Pankaj Bansal seizures, my lords. If my lord sees, there is an assumption that that an OMR sheet which has been scanned cannot have errors. There is sufficient evidence to show, and this is something which has happened in terms of improvement in technology itself, my lords, which says that where OMR sheets earlier contained alphabets, and there was misreading and errors in terms of the reading of those OMR sheets. Now, therefore, it has been moved to multiple choice questions where the technology that is being used is merely to read a marking which is just filling in a round, my lords, instead of entering alphabets. Therefore, my first submission, my lords, is an assumption that an OMR sheet scanned is valid to decide whether a person is tainted or not in itself would be specious and would be unfounded, my lords. The second aspect that I'm submitting is today there is no evidence before my lords to categorize anybody as tainted, because what is being relied on, let us assume, my lords, there are three sets of electronic records that have been recovered. One from SSC, where CBI has clearly said that the scanned documents are no longer available with SSC. All that they have are the ranks. Therefore, we are left with two other seizures, one from Pankaj Bansal, where supposedly a 65B certificate is given, and one from DataScan, whose very existence in the entire process is not substantiated. Assuming they have some copy, my lords, the provenance of that copy being original is not established. In fact, the so-called 65B certificate of Pankaj Bansal clearly shows that he only has external devices which are copies. And the 65B certificate at best reads like a seizure mahazar and not a 65B certificate. Therefore, I only want to draw my lord's attention to two aspects.
My lord,
33,
I'm
my
in
lord, if
item
I may just,
34.5.
complete only on this aspect, my lord. May I only draw my lord's attention to para 33 of Arjun Pandit Rao and 25, only to say that one, what is required for a 65B is for the computer which originally had the data to be proven to be working properly and to have data input in the ordinary course of business.
Please, that's not correct. What it means 65B only requires is the person who's producing that data should say that this data from the computer as originally he had uploaded it.
My lord,
And that Pankaj Bansal is in a position to
my lord,
say,
may I only,
because he's not an accused
my lord,
proceeding.
in fact, in page 25 of Arjun Pandit Rao, the court distinguishes between original and a copy, my lords.
Yeah, correct.
And also, my lords, point to
Original and copy.
65B
One
clear.
is
My lord,
original and copy.
only one as
Original and copy also, there's a little, let me put it. Suppose you receive a CD.
Yes.
That's the original for you.
It
But
is
the
not.
CD may have been taken from another CD, or it may have been taken from X, Y, and Z. So when you give that,
My lords, I'm obliged.
1 minute, please. So that's a problem with electronic evidence. That's a problem because it can be transferred from one source to the other source to the third source. And if you look at the definition in the Information Technology Act, you'll come to know each are treated as original.
My lords, I'm
Lord,
obliged for this.
Lord,
my
I
lords,
am-
if I may just
Lord,
clarify
I am
what
in
my lords
item
said, please.
34.
My lords, if I may just take 1
I am
minute
in
to
item
clarify this, my
34,
lords.
5.
What my lord
That
said
is-
leads to what I was submitting, my lords, which is
Not required.
that the provenance in
we are
terms
not
of
being
where
strictly
CD
going
has
by-
been made,
we are
where an external disk
We are
has
not
copied from has to
strictly,
be set out.
1 minute please, we are not strictly going by 65B. These are
My lord.
proceedings. evidence
But
of-
in which case,
Lord,
then
I beg
the
to appear for-
category shown as tainted cannot be treated as tainted as our submission, my lords.
Lord, I beg to appear in
Lord,
SLP
item 34.5, Saddam Hussein's petition, my lord. I want 30 seconds, my lord.
Okay, yes, yes, sir.
I'm 30 seconds, my lord. This is
Just wait,
Saddam
just
Hussein's
wait,
petition.
please. The ones who are joining us through video conferencing will have to wait after the physical, after we have heard the council who are present physically.
I'm appearing in SLP 10617 for the Group D candidates. I want to draw your attention first to para 340 of the judgment.
Yes.
May I read to your lordship? Should be page 269 in the machine.
Yes.
In the facts of the present case, thank you. In the facts of the present case, the writ petitioners had approached the writ court primarily to secure employment for themselves. Lordships have it now?
Yes.
To secure employment for themselves. Please mark this. Orders had been passed in the writ petitions. An investigation had been carried out by the CBI, which disclosed a scam of an epic proportion. Order of the investigation through CBI had not been interfered by the Supreme Court. This is palpably wrong because in para 9 they say there is no cognitive evidence. Please go back for further investigation. CBI had registered 4 cases, filed charge sheets and supplementary charge sheets therein. State has taken into consideration the subsequent events and at the level of the cabinet decided to create supernumerary posts for persons who had been granted appointments illegally. Though, therefore, we are obligated to take into consideration the subsequent events, more the reliefs that the parties are entitled to. We have to provide substantial justice between the parties, take cognizance of the subsequent event and grant relief. Now, if you are to look into this aspect, not all the candidates are tainted, but you've cancelled the entire selection process which has taken place. We were appointed in 2018, we continued in service, and our services were terminated in 2023 based on premises which the court says is yet to be established in Lordship's judgment of 2011. You remand it back, say, please find out the causes. None of that has gone into. So therefore, if those of us who have been appointed, we have continued in service, I respectfully submit if there is no prayer against us, then the washing of our appointments is contrary to.
Okay, yes.
Lords, I appear in SLP civil number 10545. My case is little different, my lords. I appear for 2 of the assistant teachers in the 11th and 12th nutrition, my lords. There are altogether 74 posts which were available, my lords. My case is, my lords, that there is a mismatch of marks, but in any case, my lords, even if we go by the OMR sheets, I still qualify. I am above the cutoff. My lords, may kindly see my written submission I've made.
That may not work. That, no.
No, my lords, what I am, my lords,
You're
may I just
too
make,
optimistic.
but may I just say this once.
Mr. Sharma, you're being too optimistic.
I have no, my lords, I have not been put in the rank jump. I am not there. My name doesn't find mention in the rank jump. But the only thing is, my lords, of course, my lords.
Once you are in mismatch of marks, you are in.
But my lords, may I just say this, my lords? Even if we have to go by the OMR sheets, even if I have to go by the OMR sheets, then also I qualify. And my lords, the onus cannot be on me. It would have been a
The question is not of onus, it's preponderance of probability.
But my lords, it would have been a different, my lords, why would I indulge in
When
something?
there is mismatch of marks, whole thing collapses as well.
My only submission is, my lords, if I had to gain something.
We only don't know what has happened
No,
because
my
the
lords,
original.
I ask a question to myself, my lords. If I have to
Keep on
gain
asking,
something,
it will be good.
but even in the mismatch, if I qualify, why would I?
My lords, in item.
Then why
It was
the
just one,
mismatch?
I was not even heard in the High Court.
My lords,
Integral to this.
my lords,
They have already argued that.
my lords, item 34.
In item 30.
My lords, item 34.25. Item 34.25 and item 34.92. These, my lords, candidates of Group C and Group D, they are absolutely untainted. They have got, my lords, no misrepresentation, no fraud, no forgery, nothing. They are not actually connected in any way, my lords, with the OMR sheets, number 1. Number 2, my lords, the petitions were filed, my lords, in the High Court challenging the waiting panel. My lords, at page, my lords, in item 34.25, at page 364 is the prayer. The prayer is the waiting panel which has been issued in 2019 is not in accordance with the rules, and therefore they should be set aside. It is not actually the 2017 panel, my lords, which have been published. There was no prayer at all. Actually, the 2017 panel should be quashed. All that they requested was that the 2019 panel should be abolished. Number two, 44, my lords, vacancies which were actually there, that should be filled from the reserve panel. It is not their case that none of the petitioners have ever committed any fraud or any irregularity insofar as their appointments are concerned. In the light of these facts, my lords, I submit, my lords, 3 points for my lords' consideration. One, we were not at all parties to the writ petition. We were not put to notice at all. No notice was issued by the High Court to us at any point of time. Suddenly, one fine morning, my lords, the entire appointments are quashed. Number one. Number two, my lords, in so far as our role is concerned, we have on our own merit, my lords, we have gone through and we have been selected from 2018 onwards, my lords, we have been working. Almost for 6 years we have worked now. There is no blemish found in our, my lords, work. Number two, my lords, the confirmation has also taken place. Now today, if my lords, you have to remove us after the probation period is over, and you are wanting to terminate us without even simplest of a show cause notice to us, my lords, it's completely illegal. This is number two. Number third point, my lords, my respectful consideration is, my lords have held, where, my lords, the untainted candidates, my lords, are sought to be, my lords, set aside. Their economic background, their systematic, my lords, evaluation, my lords, in their surveys, then, my lords, the livelihood which will be affected by virtue of this order, my lords, all will have to be taken into consideration. That's what my lords have laid down, my lords, in 2013-14 SEC, my lords, 494.
2013,
volume 14, SEC 494,
page,
paras 22 to 30, my lords.
paras 22 to 30. Okay.
Yes, paras 22 to 30. They have, my lords, gone into this issue. Untainted candidates cannot be clubbed with the tainted candidates for a number of factors. The court ought to take a sympathetic consideration insofar as untainted candidates are concerned, for the simple reason that they have worked for a number of years without any blemish. Number two, their livelihood is being taken away. Their economic background has to be taken into consideration. They may become overage by virtue of this, my lords, quashing. Today, my lords, the petitioners, my lords, or my lords, thrown out en masse according to this judgment, and we will not be in a position to compete in any of the examinations because we have become overage as of now. Despite the fact, my lords, we are in no way, my lords, connected with. My lords, these are the three simple submissions, my lords. I will, my lords, put a small note, my lords, with.
May I make
Yes.
only 1 minute, my lord, I won't take more than even 1 minute, I mean.
Tainted, untainted.
See, the only thing I am appearing in 34.5.50.
Tainted, untainted.
Lordship, may I have a minute?
But
I'm the-
I am
I'm-
untainted, can I, while you find out?
Just a minute, just a minute. My lord, I am appearing for those persons who are in the wait listing.
Pardon?
Wait listed candidate. My lord.
Okay.
Now, my lord, we have not been in the job throughout from 9.
The panel list, the one in the panel after expiry of 1 year.
Yes, now, no, but the
What can
panel
be
was
done
there,
for
and the
what?
people have been taken, my lord, in the services, my lord, over us who were much below, my lord, who
You
were.
come on this side, no?
No, my lord, I'm a very body petitioner. So, my lord, what I am saying in this matter, my lord, as now, there are identification of all those people who have been, my lord, irregularly, my lord, appointed. There are, my lord, the identification.
You should be appointed.
No, so no, what I just want to convey, my lord, only one thing, my lord, that now, my lord.
You will be over optimistic.
Another 1 minute. My lord, what I am just saying, my lord, now at this faggot, my lord, after 8 years of, my lord, being in the, being, my lord, out and not getting job, now it's over, we have become overage, my lord. And now it has become difficult, my lord. And all those people who stand for the irregularities, they are in the service, my lord, they are going ahead with this. So,
Okay,
my lord,
next.
only thing is,
Okay, that's all.
Lords, may I just have a very small this thing? It is to assist my lords also to identify tainted from untainted. It is there in CBI's own affidavit. Those who are the submissions filed herein. Would my lords please turn, just can you allow us please? My lords may see page number 27, my lords, in volume number 6 of written submissions filed by CBI. CBI gives the number of the cases, gives the total candidates,
My lords, in
We have
this,
got this list, we have got this list.
so my lords, I'm saying I come in the category which was appointed in the 8th counseling round of the waiting list,
There is a,
but does not
we
appear.
have understood this argument, but there is a counter argument which you'll have to answer.
Please, my lords.
Look, the CBI will only file prosecution where they've got concrete evidence that this is done illegally.
Please,
Correct?
my lords.
They identify
Yes.
the cases where they have been able to
Please, my
identify and say these are the
Yes.
cases where we have certain evidence.
Please.
Whereas what is examined by the High Court is much broader. It's much broader. It's much broader principles. Even if they are not, CBI is not able to find all the evidence against somebody, what is the consequence of this exam? Whether they will be able to find out whether there are more people who are tainted or untainted.
Yes. So may I answer that
And then
squarely?
they reach the conclusion, it's impossible for us to verify.
Yes. So, my lords, may I answer that very squarely? CBI came with one list on which it believed was really tainted. I would take that. The West
Only
Bengal,
argument you
now
can,
my lords, West
only
Bengal,
argument you can raise is, really speaking, is simple, or not so simple, is that, which you can argue is, the High Court should have gone with the presumption that only people who are tainted are the ones tainted. There's no other evidence available to show that others were untainted. That's all.
I am so grateful. So, my lords, I would only show you just one more
For
page.
that, you don't, we
I
don't
would
require so many arguments, but so many different.
No, no, my lords, then I'll just show you one more page and I will rest it there because that's the material on record which High Court could have looked at. Number one is the submission of the board, which is in line with what CBI is saying. But before the High Court, they had filed a document in which they had clearly said, so far as we are concerned, the appointments are only on the merit, except for the fact that the panel had lapsed. So they
Parallel lapse, obviously there's some, then there is a wrong thing which has been done.
My lords will find this at page
One is, you
2624.
are the ones who are in the lapse panel?
We are after, my lords, we were the waiting list. Counselings were held later on. If my lords go by the principle of a lapsed panel.
Please, how do you justify your appointment? Answer
So, my
that.
lords, let me
Forget
answer
about
that.
the tainted, untainted list.
So, my lords, let me answer that. So far as within that period of 1 year, there are only 2 sessions of counseling that took place. All the others were in waiting list. Subsequently, there were 10 sessions of counseling that took place.
That's irrelevant. That's irrelevant. Counseling.
My lords, may I just read this at page 2624?
Can panel be extended? Answer is no. The number of.
My lords, then I would really request my lords to look at the judgment. Then could the High Court would have taken off people who had no allegations of either OMR or to be under the rank jumpers against them, and were only for this. My lords, the only one paragraph in the impugned judgment.
That's the
My lords,
reasoning given by the High Court is, when we have so many irregularities being committed on every aspect, it's impossible for us to find out who are the ones who are genuinely appointed, who are the ones who had backdoor entry, who are the ones who got their results manipulated, who are the ones who got their panel, etc. over.
My lords, then that is why I wanted my lords to see that page number 2624.
Okay, please.
Would my lords just have a look at that for a minute? I'll read out. My lords, at the end of the list, it was mentioned as a note below, and this was filed before the High Court. And it says, list of candidates, which is us, because we were the only panel before the High Court, and it is decided in one paragraph 282 of the judgment. It says, note below, list of candidates called for 8th phase counseling on 30th August 2020, that is class 9 and 10. All candidates are called strictly on the basis of merit, but after expiry of panel. This was the only and only allegation, and please see how High Court disposes it of. There's only one paragraph in the judgment, no other discussion, no reasons. Page number 225, give them the page in that. It's paragraph 282, if I may read it for your convenience. It reads thus. In the facts of the present case, SCC has placed on record several persons who have been granted appointments subsequent to expiry of the validity period of panel. Such appointments therefore have to be cancelled and are hereby directed to be do so. There is no other paragraph, there is not even a whisper so far as these candidates are concerned, against whom there is no allegation either on them. They are meritorious, there's not a case of rank jumping, only and only thing is this. My lords, in one paragraph, without any rationale.
Okay.
My lord's only
Since
last
it
thing.
expired.
We left jobs
Please,
and we
please.
joined.
1 minute, please. How can you even justify parallels lived? It's expired. How?
So, my lords, the distinction of
How
the
can even
argument.
that be argued?
Yes. Now, this was argued before the High Court and it
We
was
have understood, please.
submitted that we are waitlisted
We have
and
understood.
not a panel list. We said we are waitlisted. We were in the wait list. We were
Okay,
not in
we have understood your argument, please.
My lords, only one last line, only one last line. We left jobs. We were working, we were employed elsewhere.
If we accept that argument, it may have consequences.
My lord,
Lordship, may I just take 1 minute of your
Sometimes
time?
you
My lord,
take
the
your
fact
private
that,
side
my
with
lord,
it.
the fact that the hash
But I'm
value
for the
was not taken in 2016 is crucial to the matter.
Oh,
Allow me
okay.
1 minute to explain.
My lord,
My lord, the
on the
hash value, as has been explained, my lord, is like a digital photograph of a file. You can only use the hash value if the hash value was originally taken at that time.
Then we have the original value.
But that was not done. Admittedly,
Cannot be done because
it
that
would have been
time-
done at that point. But it was
cannot, but even if the hash value original time is not attainable, it can be verified by the experts whether there were any changes made in the file after it was received.
I'm grateful, my lord. For that, the only way is for a forensic lab to look into it. And for which, as Mr. Rodgi pointed out, the CFSL report is awaited. There are only these two ways of conclusively saying that there's been interpolation. My lord, both have not been done in this.
I thought you had already argued.
So this is a different SLP block. And I'll say something, not what I've said earlier. Lord, this is an exam which took place in 16. Original result 17. Apparently between 17 and 18, the manipulation took place and some people's marks were added. That's the allegation. Either rank jumping or Lord, their marks were added in the OMR sheet. Now, how do you discover this adding of marks? You discover this adding of marks because you assume that what is with Pankaj Bansal or with data scan is the original, which is untainted, which is the original result. So that is taken as the original result. And what is with the West Bengal board is the manipulated one. And when you say that in this original result, these marks which are there in the West Bengal Commission website, 400, whatever number, 3,000 or whatever numbers are different from what was there at Pankaj Bansal's lot. And Pankaj Bansal and data scan is matching. So they say Pankaj Bansal and data scan had the original result. So up to the result and up to the declaration of the result which came to data scan or to Bansal, there was no manipulation. The manipulation happened from data scan to the West Bengal Commission where these marks changed. So how do you say that 3,000 or whatever number is tainted, or how do you say that these numbers have been manipulated? Because you say they are more than the marks that were obtaining in the hard disk obtained from Bansal. Now, if hard disk of Bansal is considered to be the original hard disk, for the purpose of this, I'm not on the technicalities of evidence, etc. I'm saying if you're assuming that, because your lordships are not looking at a probabilities case, if you're looking that to be not the original, and if the only basis for saying that there are some tainted is on the basis of taking that to be original, then Lord, the effect of the High Court order can't go beyond the numbers in the West Bengal Commission website, which are higher than what is there in the Pankaj Bansal's hard disk. Because otherwise, if this is not to be, if this goes, this hard disk of Pankaj Bansal goes, then there's nothing in the exam, because we are all working for so many years. I'm the untainted. We are all working for so many years, nothing against us. We have 5-6 years now. And we have all become now overage. We have all jobs that come. So as far as our appointment is concerned, is completely flawless. Even if we go by everything that is alleged on the basis of the investigation that has been done by the CBI, because we are part of the in the comparative hard disk of Bansal and the commission, there is no change in our marks. And the original, if that is to be considered as original, then our appointment has to be.
If I may please, your
lordship,
have 1 minute of your precious time.
There is one judgment of 2021.
I'm representing about 1,000 odd people.
Lord, there is one
all the four
judgment of 2021 where your lordships have dealt with in what cases you will take out tainted and in what cases. Just kindly have a note of that judgment, Lord, in some paragraphs.
Lordship, may I just take 1 minute of your precious time?
2021 volume 4 SCC 637.
Okay. Paragraph?
2021 4 SCC,
Paragraph?
3. And paragraph will be plot 36, 41, 43, 48, 67, 68. So your lordships have dealt with in what cases where the whole thing, where that can't be deciphered as to who are all involved in blood the mass copying or blood irregularity. Then only the whole thing has to go. Otherwise, in every case, this
May I,
could be
with
blocked. Deeply obliged.
deeply obliged lordship, what has happened? I represent about 1,000 odd people. There are seniors who are leading us in the individual capacities in those SLPs. Then 9, 10, 11, 12, Group C, Group D. I fall in the so-called allegedly mismatch category. There's one SLP that is 31169 diary number 34.104. Lordship, the reason I'm saying this is I filed an RTI application because my name was not called out in the first list. They gave me my OMR sheet and that remains untainted. That remains as of today. But by the High Court's order, that is on 7/7/2023, because I'm in 11th and 12th, 907 names were supposed to be published and we were supposed to be terminated. Now, this falls within the so-called mismatch, but there is no mismatch as far as the OMR sheets are concerned because the OMR sheets were available in 2018. 5/5/2018, Lordship, my OMR sheet is on record. This is, I'll tell you the page numbers. I'll not take your Lordship's precious time. This is diary number 31169 of 2024. The SLP is listed at item 34.104. The OMR sheets are available in annexure number P5, pages 309 and 3010. They had given me twice in 2018 and 2019, and they gave me my answer key. And I am much above the cutoff mark. What I'm trying to impress upon Lordship, even in the mismatch category, it has been given too wide a brush. I have not admitted there has been, in fact, in all the cases, there have been no.
You are in mismatch category.
Lordship?
You are in mismatch category.
I'm in the mismatch category.
Then how do you get out of it?
Lordship, because my question is, if I have to look into the Pankaj Bansal database where they say the OMRs were manipulated, the OMR was with me, the answer sheet, my answer string, my marks are there in visible capacity. They are printed and they are part of my SLP paper book because I was given those in 2018 and given in 2019 along with the answer key.
Does it tally with the board's marks?
This tallies with the
board's marks.
No, it doesn't tally with
no,
the board's marks.
my OMR sheet marks did not vary because I have my OMR sheet. That is a mirror image. The entire question, Lordship, the
information is given to the board.
Yes, it tallies with the board's result. I was given by the
minute,
tallies with the commission.
That in fact destroys the whole case then. Then it's a case wherein if you have the OMR sheet, photocopy of the OMR sheet was given to you, and that OMR sheet is not matching with the OMR sheet available with Pankaj Bansal,
that is not the case.
Then that means the OMR sheets have been also replaced.
No, Lordship, that is my case. The OMR sheet, there is no mismatch.
That means OMR sheets have been replaced because they cannot be two OMR sheets.
Lordship, the original destroyed, but this is before the destruction. In 2018, I get it.
A mismatch between the OMR sheet, has to be.
That is exactly why I am suspicious of this entire batch.
Yes, he accepts there is a mismatch between OMR sheet with Pankaj Bansal and the OMR sheet given to him. That means the whole thing is then gone.
No, Lordship,
you're supporting
with all humility. The question is, if I were to admit to this position, Lordship, then I need to
see itself has undergone changes.
With all humility, Lordship, if I have to admit to that position.
OMR sheet has your name, it is your signatures, it has your roll number.
Yes, Lordship. Your Lordship may kindly have a look at it.
Thank you for supporting them. Please.
Your Lordship. No, Lordship, I have not seen.
Just one minute. Malord, I have.
No argument, Mr. Patwalia.
Malord, yes, I just want to point out one thing. I have filed an additional document. I have filed a supplementary charge sheet dated 8th January 2024. I want to read only one paragraph from that supplementary charge sheet. The High Court takes the CBI affidavit of 5th February 24 as the gospel truth and says, it says X tainted in one category, Y tainted in the second category. What this 8th January 24 charge sheet shows us is that there was another hard disk recovered from Niladri Das,
Correct.
When that hard disk is compared, there are only 152 mismatches.
Oh, yeah, that's been argued.
Your Lordship may permit.
Lords,
I am
before
in the
they
corner,
begin,
my lord.
one very limited point that my lords had asked them to file. My lords had said, let them, since the High Court has swept aside, my lords, the Evidence Act, they have swept aside the Secondary Board of
Why
Secondary Education.
swept aside is never applicable to writ petitions.
But my lords, those arguments, they have said these are not relevant. This is not relevant. The 2016 rules are not relevant. None of it is relevant. But my lords had told the CBI that you must file an affidavit which contains the metadata with regard to the comparison of the hash values of Data Scantech and Pankaj Bansal. My lords, that affidavit has not been filed. My lords have directed them. And my lords, that affidavit will show that it was not on the date. But my lords, let's file the affidavit.
Okay, we're closing now from this.
Yes,
My lords,
yes,
let them file the
one
affidavit.
statement, my lord.
Allow me to
In-
read
in-
one.
Your Lordship may,
To argue
That's all.
from
Your Lordship may, Your Lordship may note down only one page, my lord.
Lords, allow me to.
Your Lordship may note down one page, my lord.
Just
In
one.
SLP
No, I
1611,
I've been trying to ask.
Okay, please.
my lord, my lord,
It is para 289 from the impugned order. What it says is this, it is in support of segregation. The 3 hard disks seized by CBI had been produced in the court. CBI had granted inspection of documents downloaded from such hard disks to persons seeking such inspections pursuant to the orders of this bench. None of the persons taking inspections have contended that the OMR sheets are not theirs. Please note this, my lords, now. The OMR sheets bear unique barcode and have several features which distinguish one OMR sheet from the other, such as the signature of the candidates, as also the invigilator and other aspects. Now, read with this, my lords, I rely only upon CBI's para 12, CBI's written submissions, which says this, that if required, the CBI will provide the details of the individual candidates who received appointments illegally, as mentioned in the above mentioned tables. I'll just end it here. Lot has been said here by one statement. I had nothing to offer but my merit then. I have nothing to offer but my merit now. In future,
Your Lordship,
anything.
One person more, just one person more. We close.
one page, my lord, only in 16111 SLP, my lord, volume 2, my lord, page 6761.
What do you want to say?
My lord, these are 47 petitions.
Tainted, untainted.
All untainted, nowhere in any of the lists. The chart that I have placed, my lord, in volume 2, this is,
What do you want to argue?
my lord, they have from 2014, 16, 10, 2006, they have been working somewhere else. There also their appointment was clean. For their future advancement, my lord, they preferred to join this position, my lord. Here also they are untainted completely. And at this stage, where against me there is nothing, I am being told that you are out. So that's why, my lord.
Only one submission.
My lord.
103.
I will only hand
My
over
lord,
this.
just one
There is one
submission.
unique case, one of a single candidate where, my lord, under the orders of the court, my lord, when somebody jumping over me, I approached the learned single judge. My lord, my item number is 1.90, so 34.
Mr. Dolaki, you will be in the same position.
And
Okay, on this side we are closing. Now we'll keep it for.
Just a minute, by clock, just a minute.
Okay, just 1 minute. There is a council who wanted to address us through video conferencing. Let him come. Let him say.
1 minute, my lord, I am in item 34.5.
Yes.
This is Saddam Hussein's petition, my lord. I am group of about 58 people, and we are untainted, my lord. My lord, your lordship has been inundated with the factual and technical metrics of the matter so much that your lordship is fully equipped now to do justice to everybody there, because it's a right to life, right to live, and right to employment. And we are untainted group of 58
Okay, fine.
people.
Just 1 minute now.
There is only one. Lord, under the orders of the learned single.
Oh, it doesn't make a difference.
The division.
No, that issue was slightly different. Relist
Your Lordships may just hear me for 20 seconds, my lord. My case is slightly different, my lord. Lord, I am in a very peculiar position. What the High Court does, my lord, I am untainted. I have worked. But during the proceeding before the learned single judge, I was asked to deposit entire 4 months, 4 years salary, my lord, which I have done. And that was supposed to be given to, my lords, one Babita Sarkar. Subsequent order says, my lord, Babita Sarkar is also tainted and she is thrown out and my lord's appointment is given to a third person. But I am saying my money, my lord, which I have rightfully earned for 4 years, I'm untainted. How can my application, my lord, that money may be secure till your lordship decide ultimately, my lord, who gets what?
Kama, we are not going to help you in that case.
My lord, my hard-earned money, my lord, of 15 lakhs odd, which I have earned, High Court, my lord, says that you deposit, I have deposited the money.
27th of January 2025.
My lord, I had a small.
No, there is one.
No, my lord, I am not covered by that, my lord. I am not covered by that. Kindly have my IA, my lord. 256034.
Lord, there is.
Tomorrow first matter, is it possible?
My lords, I'm.
Lord, there is. Lord, for the state. Not 1 minute.
10 seconds, my lord.
My lord, tomorrow, can it be possible?
Last occasion to hand over.
Lords, for the state of UP, state of West Bengal, your lordship said that point number 2 will be argued later, my lord, that relating to the government order, my lord. Direction number 8.
That is it tomorrow for me? No, tomorrow morning I believe.
No, not 20 tomorrow.
Not tomorrow.
No, because we are sitting in 3 judges bench.
Okay, 27th.
Regarding what?
27th, our
Monday. So you give a copy to the other side, we'll take it up on the next one.
But 27th, Lord.
I'll not keep it, I'll give another.
Oh,
My lord, I had a small request, not at all on the merits. If my lords would
Might an earlier date be possible, either the 17th or the 20th?
20th is going to be slightly difficult.
Please.
21st, 27th, that's it.
27th at 2 p.m. Lord.
2 p.m.
2 p.m.
Fair enough.
Great.
My lord, could I make a small request before my lords close the petitioner's side?
Yes, please.
This is a matter, item 34.17. There was one of the respondents who couldn't afford representation. So he filed a legal aid application. I've come on record for him. I filed a transposition application. My only request is he may be transposed. Suppose he may sink and or swim with the others. My lords,
That will
my,
allow.
my colleague
Give
will
the
hand up.
details.
Yes.
Just give the details that application for transposition is allowed.
Let us look at the application. What has happened is many waiting state candidates have filed this kind of application to be transposed as petitioners who have got appointment. We need to see the application. Lordship may not allow today. Let it.
Okay, let it wait. Let it.
My lords,
My lord only.
would my lords only consider giving us 2 minutes on the next statement?
No more.